cost a lot of money? Is this going to be a problem? We did a couple of things. The first thing we did is if you hire somebody off the list, then it's whatever deal you work with those people. And so we have people on the list who charge lots of different things, and people to some extent can pick and choose based on that. If we randomly assign somebody, we have a default rate which is $200 an hour. But we also have a very generous pro bono rule in our program in which we say, if you want to be on our list of approved mediators, you will agree to take at least 2 cases a year if we ask you to that are pro bono. And if a party files a motion which says it would be a financial hardship for me to go through this mediation, here's an affidavit that shows we can then grant pro bono status. And we're relatively liberal about doing that, understanding this concern about the expense.
So how long do the mediations in the appellate context that you're personally familiar with?
They virtually never last more than a day. One of the things we do...
If they last a day, then $200 an hour, then you're talking $1,600, $2,000.
Yeah, we get reports from the mediators. We ask them to tell us how much time they spent and what it costs, and they probably rate. Yes, we do that on all of our cases. We ask them so we can sort of keep track. And they would generally run from, at the low end, $500 or $600, not very usual, to a high end of maybe $3,000, maybe $4,000. I think I've seen 1 or 2 that have gone beyond 1 day. But that's sort of the range.
That's the general range, yeah. 500 to 2,000.
I think that's or maybe 2,500, somewhere in that range, which, when you look at it in the context of what they're going to pay for a transcript and what they're going to pay for a lawyer all the way through, that's the balancing, obviously.
But 65% of those people
are going to do it
actually do end up paying that money and the money for the transcript because the mediation fails and they end up having to go through the entire appellate process.
Absolutely. No question about that.
What has been the other, one of the things that when you had started it was to see if the other appellate courts were interested. You had liaisons from each of the appellate courts for the subcommittee, correct?
Correct.
Why is it, since it, in your circuit, in your district, it's voluntary, do you know why the other appellate courts have not instituted? And I guess, again, we don't want to do an exercise in futility. If none of the other appellate courts are going to adopt it, it doesn't matter if we have nice rules or, because it's not mandatory. We're not mandating it. So could you sort of speak to are they waiting for these rules, or could you tell us what the situation is there?
I think there are a couple of DCAs who have indicated they really just have no interest and they probably won't do it under any circumstances unless ordered to do it. I think part of that is if they look at their caseload and they think they don't need to clear up a bunch of cases on their docket, they don't have a backlog. And so I think they're looking at it from that standpoint. As I said, we tried to look at it not just from that standpoint because we think there's some benefits to the parties that it's also creating. I think there are a couple of DAs who have expressed some interest and may just be waiting to sort of see how it all sorts out because they obviously haven't started anything yet. But at least I know the fourth has indicated, I think, that they have some interest in it, and I wouldn't be surprised if they ended up implementing some program.
Palmer, I know in Rule 9.720 it does not appear to allow for appearance by telephone, correct?
Why not permit that? I know the 11th Circuit Court of Appeals allows that, right? So why not allow parties to appear by phone?
The rule doesn't allow it without court order, but does allow it with court order. So I know the 11th Circuit does do it by telephone. We at our court allow it by telephone with permission of the court. We originally set it up and said we'd leave it up to the mediators, and the mediators said, no, we don't want to make that decision. We lose our neutrality, so leave it to the court. And it's our belief just that the court should continue to have some role. I mean, clearly the court has an interest in these things being most successful. And the court can allow it by court order, but to not make that the default position, because I think the default position is, absent the order, they should be there in person. It's more likely to lead to a successful mediation.
And is that the case? I mean, in your experience, is that the case, that if face-to-face mediation is more likely to be successful than telephonic?
I don't know that there's any statistics specifically in the appellate area. I know in some areas, I think I know in the new foreclosure mediation rules that you've just approved, you've allowed the petitioner to show up by telephone. I don't think you allow the other side to show up by telephone. So I think there's some recognition that there's some advantage of having folks there in the room. And I think that's one of those things that, with some oversight by the court, they can look at it on a case-by-case basis. We tend to grant those if there seems to be any kind of legitimate reason. We get motions that say, I'm in California, it would be expensive to come here, I'm on a limb. And we're fairly generous in granting them, but if you get ones that look more like they're just going to always ask to come by telephone just because it's easier for them.
Do you do family cases by, have you picked out, it seems to me if there's one type of case that would benefit from not having to go through more conflict, it would be cases involving dissolution of marriage, those kinds of things. Are those included in what you mediate? And have you found, when you say the 35%, have you found a particular type of case that's more likely to be successful in mediation, or does it depend on, the personalities of who's actually showing
We do
up?
final civil, we do family. I tend to send family more because I think they are more amenable to mediation, both because of trying to deal with the conflict and because there are usually multiple issues that allow a better chance to mediate. My experience is when I look at the results as they come back through, there really aren't significant difference where you can say it works way better in family law. We try to look at, are there certain areas where it does work and it doesn't work? About the only conclusion we were able to come to is mediations that involved administrative agencies seem to have a particularly low percentage chance of success in mediation. But the other ones tend to, it's really very fact intensive in that
You
regard.
have your own internal rules about screening the cases for referral to mediation. Those types of screening process
is not included in the rules. You're leaving that to the individual courts to figure out for themselves, right?
Correct. We have 3 judges who each screen a third of the cases. We send out a confidential questionnaire. Should this or should this not go to mediation? Why or why not? And then we make those decisions on whether they should go. But the rules not really address that. We thought that was one of the things that ought to be left to the individual.
How can an appellate judge, looking at just a final judgment, having no record, no file, no nothing, make a decision on, this one ought to go?
Well, we can look at some and based on what reasons they give us, determine that this is not a sufficient reason not to go. For example, when the questionnaire says, is this appropriate for mediation? Why not? And they say it's not appropriate because somebody's already won below. Well, that's not a very convincing argument.
Well, no, I
because
understand.
every appeal is like that. On the other hand, when we get one that says, we're looking to get an opinion because we've got 100 cases in the pipeline and this is going to be precedential, that's why it shouldn't go, it's more likely not to go. It's really, as opposed to looking at it to say, is this a good one to go to mediation, I think we look at it from, is there a legitimate reason not to send this one to mediation?
But it's based then upon just the representations of the parties and not, it can't be based on the actual record or
Correct.
what the case is about. So it has to be the subjective
Correct.
Statements of, okay.
And in our case, it's a relatively short statement because what we didn't want is for them to be filing a first brief to try and get a first crack at the court. And so they're relatively short. But we will get things that tell, if there's a history of domestic violence, for example, that would be, if it's clear that the parties are talking to each other, they have lawyers who are talking to each other and they're doing a lot of negotiating between them, that's sometime an indication they think they can do it on their own. And we might defer to them in that regard.
Well, you are well into your rebuttal if you want to save the last couple of minutes.
I think I'll just save the time for rebuttal. There are a few issues that were raised by the appellate section. A couple of the rule changes they propose we've said make sense to us. A couple we've said we don't think they're necessary, but if you want to make the changes, we're okay with them. And a couple, like the telephone and the certified mediator, we've set forth in the papers why we think they're probably not appropriate. Thank you.
All right, thank you.
May it please the Court. My name is Paul Regensdorf. I'm with Stearns Weaver in Fort Lauderdale, but today I'm appearing on behalf of the Appellate Court Rules Committee, not the Appellate Section. I do not speak for the Appellate Section. They have not really taken an opportunity or had an opportunity to speak on this. I'd like to start by going back 1 week when your honors entered another order.
When you said they haven't had an opportunity, this has been around since 2004.
Yes, ma'am.
Do you feel that this hasn't been properly aired?
Well,
I just want to make sure about that.
I would be less than candid if I said, well, let me say this. The appellate lawyers were not significantly included in this process. I'm not, my nose is not a joint, but what happened is all through 04, 05, 06, 07, 08, as it was being circulated to the appellate judges and being circulated in the mediation world, it never got circulated to the appellate lawyers, any group of appellate lawyers that I'm aware of. No appellate lawyers served on this committee. No practicing lawyers served on this committee, something I think you might want to address in the future. There should be real lawyers on this committee. The Appellate Court Rules Committee, and I was the one who picked it up a bit, got this issue in April of 2009 with a response date of May 15th of 2009. And that's what we put together, this product, within that period of time. We got a little extra time. So I'm not suggesting we haven't had a chance to look at it, but we came very late to the table at a point in time when the rule was largely chiseled in stone. We're trying to chisel a portion of it, not undo it, to my good friend, not undo the rule, just change it some. And I'd like to start if I...
I thought that the Appellate Rules Committee's basic objection was to having uniform rules at all, and that you thought it should be left to each appellate court to make sort of its own rules about how to do mediation if they wanted to do it.
I don't think that was our main position. I think that makes more sense because I don't have a strong feeling that all other 4 districts plus this court want appellate mediation strongly. But I don't think that was our main position. I think our main position was this, and it gets to 3 points. A week ago, Your Honors issued another order on mediation dealing with marketing of mediation, a much more narrow topic. But I was pleased to see in that opinion where you talked about things mediators shouldn't do as the most important thing that you put on the list. You listed first that they can't do anything to diminish the importance of a party's right to self-determination. And that is absolutely correct because mediation, more than any other part of the process, is the party's decision. If you've ever sat through mediation, the first thing the mediator says is, I'm not going to do anything today. You're going to make the decision today. And that's what it should be. And frankly, the lawyers didn't have the opportunity to put in their 2 cents as to what the clients might want until long after the process. The mediators did. They're the least important in your consideration. The mediators are getting paid to do a job. They have no independent interest. They certainly have no interest in how the decision comes out. Judges, appellate judges, have no interest at the mediation stage in how a decision comes out, because they just want to get rid of cases at that point. Now, if it gets to them for decision, of course, they become critically important in the resolution. But they don't review mediations for fairness. The people who want the mediation to work well are the parties and the lawyers that represent them. And the Appellate Rules Committee had 3 or 4 primary concerns where if the parties agree to something, they should be able to get it the way they would like it. And the first is the timing of the mediation. The vast majority of appeals, probably they're small appeals, costs become a significant part of the calculus, and it certainly makes sense to try to get those first. And that's fine. That can be the default position. However, if 2 lawyers, if Justice Perrianti and I are opposing counsel, and we say this case needs to be developed.
Why'd you pick me?
I don't know. Justice Lewis,
we've fought many battles, so
because you are the least reasonable. I have no idea. Most reasonable. If 2 lawyers say, appellant and appellee, this case needs development, let's not do it at the beginning. And think of all the reasons why. A new appellate lawyer hasn't even read the transcript, hasn't developed the argument, hasn't developed a client relationship yet where he or she is going to try to convince a client to pay $20 million to settle this case.
Well, isn't there some built in this rule that you can ask that mediation take place at a later point?
You can ask. But the point is, the principle of self-determination. If both attorneys come to the court, and that's what our proposal says, our modification, when both counsel come to the court and say, we think it's better to do it later, let us do it later. The court shouldn't say, well, we'll think about it. The court should say, you're right. And the point is, there are multiple benefits. There's no automatic tolling then. The way the Rules Committee put it together, there's an automatic 75-day delay in the process while everything stands back, while we see if mediation is going to work at the beginning before the lawyers, especially the new appellate lawyers, know what's going on. The way we've proposed is let the case run if the parties so choose.
How does it work in the 11th Circuit?
It's early. It's done early also there.
Do they have the option to postpone it?
I'm sure they have the option to ask. I don't know that they can control it. I don't know that they can control it. But to me, it just makes so much sense if the parties want that to be done. We've set it so that the mediation would happen no later than 20 days after the briefing ends. The court's activity really hasn't started at that point. No one's written a memo for the bench yet. So let the parties control through their self-determination the time.
With that, after the parties have filed their briefs, we've already gone through the expense of doing the transcript. There's lawyers' time and effort put into doing the briefs, and I'm sure someone's going to be billed for that. So, it seems to me that at that point, you're not saving a lot. Well, if that's the point that you're going to start the mediation.
You may be resolving the case in the appropriate way. If the only purpose is to save money, then do it on day one. And force the lawyer to make a decision on mediation and try to convince his client that he doesn't even know yet or the issues to do it on day one. The purpose is not just to save costs. It is to reduce costs when appropriate, but to let the parties self-determine when an appropriate case is to let it work a while longer.
What you're really talking about is doing it by stipulation instead of court order.
That is absolutely correct.
I cannot imagine a district court of appeal on a consented motion or agreed upon motion for an extension of time somehow denying that. Has that been your experience?
I don't know that I've never had that experience. My point is, if it's
the other problem is, it seems to me that according to professional lawyers, where you have a stipulation, that would work just fine. Amazingly enough, there are fights between lawyers as to whether they got an agreement or not, somewhat regularly.
Of course.
So doesn't that then present another issue that then we can just avoid by having a court order resolve this?
Well, there would be a court order. If you and I were opposing lawyers and we couldn't agree to do it later because you wanted to run through, you've got your $10 million judgment, you don't want me to find that error that you know is there, you oppose going late, sure. Then I file a motion with the court and say, here's why it's appropriate, please let me go later. And then we put it back to the court. We can do that now, but the point is if you and I agree, why should there be any uncertainty about that? Let me go to the second issue because it's also a self-determination issue, and that is selecting the mediator. And with all due respect, if this court does not realize that there is a divide in the practice of law as to whether a mediator certified and trained is always the best person to mediate. Many lawyers think it's not always that case. I've been trained as a mediator, and I had tremendous discussions with Perry Yitkin about that, and we disagreed. Our position is simply this. If the two parties agree by their self-determination to select a non-certified mediator, it's not that we should have the opportunity to ask. If we agree that that's the best person to mediate this case, whether it be an experienced appellate lawyer or a lawyer experienced in the subject matter that we are fighting, that should be our decision. And if that person may be a retired judge who never got certified as a mediator, if that's our decision, what interest is it of the mediators or the court, as far as the mediation goes, to stop us?
Is that not permitted by these rules?
It is permitted if we request it. But the court does not have to allow it. There's a comment that they have added which sort of softens the rule. The rule says you can only get a certified mediator. It's a wonderful concept, but respectfully, many good mediators don't become certified for deliberate reasons because that's not their style of mediation. All we ask on this second point is self-determination. If you and I agree to a particular mediator, and it's going to be retired Judge Justice Perry, why shouldn't we be allowed to do that? We have the interest in that mediation. The third point is the issue raised concerning appearance at the mediation. If we agree that the parties should not have to come and can appear by phone, who has a greater interest than the parties that agree? And we have asked in our papers to allow the parties to agree to not have to come in person, especially if it's an early mediation. Think of this. They've just mediated the trial proceeding very close to trial. Then they've come down and sat through a 4-week trial and gotten slammed for a bunch of money or won a bunch of money. And then at the very beginning of the mediation, they're being commanded to come back for another mediation. If they choose not to and the parties agree, why shouldn't they have that right?
Are you surprised to hear that 1/3 of the civil cases are actually
being resolved in mediation. I mean, that's pretty, if someone says it's low, to me, considering whatever you said, you'd think there would be much smaller than 1 in 3. And I guess this is my concern, is I know you make a very compelling argument about the exceptions, but the appellate lawyers have an interest that may at times be separate from the clients. Now, you may not agree with that.
Of course. You mean a personal selfish interest?
Yes.
So the world is the world. A good lawyer should never have that interest, but of course, a lawyer, an appellate lawyer, could pump the case through mediation to get some more money.
But you act as if the court's interest is only to try to clear its docket, when we all know that if a mediation is done properly, it's not about the legal issues. It peels those away to get to what is at the heart of why the parties are in disagreement.
I didn't mean to make the court's role de minimis, but the point is, in mediation, the court does not supervise the result. The parties dictate the results. What mediation is. Self-determination should control when to do it, who judges it, and who is present. The civil rules allow that. I don't know why the appellate rule changes that. It makes, to me, no real compelling sense. Self-determination, Your Honor said it a week ago. The fourth point, which is less important than those three, those are the three, in my opinion, compelling points that the Appellate Court Rules Committee had to make on behalf of appellate lawyers. The fourth point was that the partial listing of excluded cases is by no means complete, and I think the 5th District's practice has worked very well, that they don't have a hard and fast rule. They know what types of cases work. I would delete that section, the committee, would delete that section entirely and leave it to each court if you decide to impose it on the appellate courts. There's no reason to try to list some and miss a lot of them, because there's a lot of cases that are inappropriate. I think there's some that probably could have been included. So we would not put a partial listing of those which are excluded from availability for mediation. The other thing that the Appellate Court Rules Committee did was to, in the time we had available to us, go through the rest of the rule. I don't suggest we're all experts, but we draft a lot of rules. And perhaps the Alternative Dispute Resolution Committee doesn't draft as many rules. There's some things in the proposed rule that are not very rule-like. For example, there's some portion of the rule, I could find the number, where it says that somebody shall promptly file a response. Well, rules of procedure don't use words like promptly. They say you've got 10 days or 10 days after service or something. So we have gone through and taken the rule, because we're not against mediation. It's a good concept done properly, especially when you re-emphasize the self-determination. And Justice Pariente, as to the 35% success rate, with all due respect to the statistics, and we attach them to our papers so that you would see them, some of the cases settled before mediation. Now, the 5th District likes to take credit and say, well, the reason they settled is we sent out that notice of mediation. Maybe. There's nothing that says that's why they settled. Some appellate cases just settle because people go away and work it out like good professional lawyers should do. Some of the cases settled after mediation. Maybe, and I think in that number, which is certainly less than 35%, it's less than 30%, I believe, some of those were set in mediation, and the mediation should get a check mark for that. Doesn't mean they wouldn't have settled without mediation, because good lawyers, if we've got a case, hopefully we'll talk about trying to resolve it before we spend the client's money, if we're professional lawyers. Now, if we're going to write rules because we think all appellate lawyers try to pump their files, well, then we've got a sad state for appellate practice. I don't think that's the case with appellate lawyers.
Mr. Regensdorf, you need to bring your argument to a close. You're well past your time allotted for argument.
We're not arguing. We are making comments to this rule for the court.
Well, bring your comments to a close.
That's an excellent point, Madam Chief Justice. And let me bring my comments to a close simply by saying that I don't know whether this is a good idea for the other 4 districts. You're going to have to talk to the other 4 districts on that. I have some thoughts, but they're anecdotal. But as to appellate lawyers, who are really the closest things to the clients, the public, and the lawyers who represent them should be more involved in the process earlier. And since this court has recognized the critical importance of self-determination in this phase of the appellate proceeding, mediation, it's the client's part of the phase. It's not the mediators. It's not the judges. Please focus on the 3 things. Do we have to do it early? Or if we agree, can it be automatic that it will be late? Do we have to have a certified mediator? Or if we agree, can we take that certified mediator automatically? Do we have to be present? If we agree that we don't have to be present.
And with that, thank you very much. Judge Palmer.
Thank Thank you. It seems to me the most important thing to say is to remember that the context in which these rules are likely to be applied are not limited to cases where parties have gone out and gotten new appellate lawyers. They will include cases where there are no lawyers. In our case, we don't do it right now with pro se's, but under the rules you could do it with pro se's. And a number of these rules where the argument is let the parties do it whatever they want, just stay out of it. I think if you're going to be dealing with pro se's, maybe it makes sense to have some more court involvement with it. If you have the problem that the appellate lawyer's not in to get up to speed, that's one more expense that you save potentially by the early mediation. In addition to the transcript, in addition to the record.
But isn't, if an appellate lawyer has been, assuming we have an appellate lawyer who's been retained to handle the case, and at that early stage, it seems like it's quite difficult for the appellate lawyer to necessarily adequately evaluate the case and to determine the likelihood that his client or her client will prevail on appeal. And it just seems to me that you can, it gets them to the table, but if they come to the table without knowing everything they need to know, I'm not sure how helpful that is. Or when they feel that they don't know everything they need to know.
One of the ways we deal with that in the rule is to make it clear that trial counsel can do the appellate mediation, or appellate counsel can do it, or both can do it. They don't have to be there, so you have the benefit. Even if you're going to mediation within 30 days, yes, you don't have the record yet, but you have the ability to talk to trial counsel. You can get some feel potentially for what the issues are.
Judge Palmer,
and I think that's a trade-off.
It seems to me that most evaluations at the appellate level really come not only after the record comes in, but after you see articulated for you why you're going to lose this case in the brief of the other side. And that's when you're really armed to make informed decisions. And so I have some concern, having done primarily appellate practice, that that's the point where you know the strengths. And sometimes they point out problems in your case that you didn't know you had. And so, I mean, these are the kinds of things, seems to me, that from an appellate perspective, for the client's benefit. I can understand courts, and since I've been on this court, it's always, how many have you closed? How many cases are you, where are you on that? But that should not be, should it? The real guiding principle, shouldn't it be?
Absolutely not.
As counsel?
And we didn't set up our program to say how many cases we can get rid of. We really set it up partially with an eye towards what would be a benefit to the clients to be able to have an opportunity to do this before all those expenses are incurred. And I think the way the rule is drafted, which allow the parties to come to the court and say, this is why this one ought to be put off, gives the court that discretion, but it gives that shot to the client before that.
Also, could I ask a question about this was sort of premised on this is going to be ordered and because the DCAs want it. This court has not voted that it wants or demands it, so what's the status on that? I mean, are we talking about something this morning? We're going to be passing some kind of mandatory kind of something that courts that don't really even want to do it, or the other four don't want to do it, so we're here talking about what the fifth wants to do? And
the very first rule says the court may, on its own,
I understand, but
send a mediation.
What's the landscape?
I think the landscape is that we know it's been 6 years since Chief Justice Pariente suggested other courts look at it, and then they haven't. We're the only one who is doing it at this point. It may provide a framework and a structure that would encourage other DCAs to do it. If they end up not doing it, so be it. But I think if they are interested in doing it, it is much easier to implement a program with a framework in place than simply having to start from scratch like we did at the Fifth. But again,
the landscape I was asking about, do these other district courts of appeal want to do this?
I'm guessing that if a set of rules was in place, one or two might do it. The others won't.
We don't know that. We haven't had response in this whole process from any of the other DCAs?
No, they all had liaisons to this group. They all helped put these rules together, and they
never voiced, never discussed.
They voiced approval of the way the rules were put together. They didn't voice it in the context of, and if they're put in place, we will then set up the program.
Again, I want to make sure we had representation from all five districts, and nobody's. So this is, if the district wants to do the program, this is how they'd set it up. But I wanted, if you could just respond to Mr. Regensdorf. Is there a reason why, if the parties stipulate that they want to do it later, has that happened in the Fifth, and do you uniformly
I
granted?
have never denied a motion to continue a mediation that has come before me in the Fifth.
So shouldn't we just make that clear so that, because it certainly what he's saying makes sense, that will...
My only concern would be you could get into some sort of abusive situations where somebody was doing it in every case and none of their cases were settling and they were really just doing it for convenience, and there's something to indicate that...
But if both sides have to stipulate to it, so, I mean, if neither side are saying we think this
well, and if a lawyer convinces a pro se, for example, we ought to just push these things off, and you've got a situation, if you've got a mortgage foreclosure firm that's got lots of pro ses and they're doing it every time, then maybe the court ought to be in that position to say maybe we ought to look at something different for these.
What if it's lawyers on both sides?
I think it's much less likely a chance for abuse. There's always still some chance.
And with that, thank you very much. I thank
you,
you both for your arguments here today. We really appreciate your thoughts on this matter. Okay. I understand that we have a group of pages here from the Capitol, and we want to welcome you to the Florida Supreme Court and hope that you enjoy your stay here with us and learn something about our court system. The next case on the court's agenda is State versus Isaac. Ms. Gard, are you ready to proceed?
I am, Your Honor. May it please the Court, Christine Gard on behalf of the State of Florida. I'll just run through a quick timeline of these facts because each and every one of these cases is in a different procedural posture.
Well, let's talk about it, Isaac. And let me just get you to state at the outset, if you would, what we're reviewing. Now, in this case, are we reviewing a decision of the First District, which was on an appeal from the denial of a 3800A motion? Is that correct or incorrect?
I believe it is. That's where it gets a little interesting, Your Honor. It looks like it's either.
Well, post-conviction
It
motion.
looks like it's a post-conviction motion.
Okay.
It looks like a 3850 as opposed to 3800A.
So we're here. We are in post-conviction land.
Yes.
Is that correct? Okay.
Mr. Isaac was charged back in 1995 with a series of crimes. A portion of those proceeded to jury trial, which is the portion challenged here. Another portion pled, which received a consecutive sentence. He was originally sentenced within the guidelines to 20 years. As counsel pointed out in his brief, it is within the 244-month upper limit of the guidelines at the time. Now, those are the 95 guidelines. So he comes back, and there's a remand after direct appeal, and they strike the theft count because it's duplicative of one of the other charges. So that's in 1999. Then he files a 3800A motion on June 2nd, 2000, pursuant to this court's decision in Heggs. So we end up with Apprendi coming out shortly thereafter on June 26th. He files a 3850 on November 15th, 2000, alleging...
Let's go before you get to the 3050. He's resentenced in 2001, you said, after Apprendi came out.
That's on the Heggs resentencing.
On the Heggs, so his resentencing. So the issue that we never resolved in Glenda's, and I know we can spend a lot of time on the procedural posture, but is that if there's a resentencing for a case where the conviction and original sentence was before Apprendi, but the resentencing is after Apprendi, and in some of these cases after Blakeley as well, do Apprendi and Blakeley, depending on where the sentencing, do they apply to the resentencing procedure? And the state's position on that is no. You look back to the date of the original conviction and sentence, and the First District's position is no, you look at, because resentencing is de novo, you look at the date of the resentencing, and if the cases were decided after Apprendi or Blakely, they should apply. That's the. I mean, even though the procedural posture is different, that's what we've got to. What we didn't decide in Galendez that we're supposed to be deciding in these three cases. Is that correct?
Correct, almost. In this case, we actually have an application of Blakely long after the resentencing became final.
And this case may fail because of that. That's why I said this was after. The resentencing was before Blakely.
Correct.
And that's maybe that as well as the fact that in this case, subsequently, the First District came out with a decision saying it was harmless error beyond unreasonable doubt. I know we said don't address it, but the First District's already kind of decided that issue, or they have.
I believe the First District beat both counsel to the punch on that one.
But in this case, it seems
resentencing was final in 2002, right?
It was actually would have been final 30 days following the June 11th, 2001 sentencing under Heggs.
But I thought in that same proceeding, wasn't there? He objected to the resentencing. He brought his Apprendi issue at that time.
I jumped the gun.
And so Apprendi was, in fact, a part of that resentencing.
I apologize. I jumped the gun. There was a 3800B1 motion. I just looked down after I answered that question. I do apologize to the court. He filed a 3800B1, and that's where we get to Isaac 2, which is final, July 23rd, 2002, or shortly thereafter when the mandate issued.
Your position would be, even if your position is you wouldn't even look to the date of the resentencing, you would look to the date of the original sentence.
Correct, and we find that language from Hughes, the instruction given in Hughes, and the discussion of the court in Hughes where they discuss conviction versus sentence. The state's interest in the finality of the conviction itself, which is what occurs in this case. The state was able to try him and have those elements be found.
Yeah, that's fine, but you then, the judge found that he would have been sentenced within the guidelines based on Heggs, and the judge found a progressively increasing violent crimes constituting a escalating pattern of criminal activity, and that would be a fact. That's the argument they're making, that would be required to be found by a jury based on Apprendi.
Well, the state's position on that, no, that is not a fact that needs to be found beyond a reasonable doubt.
Well, then we wouldn't have then this wouldn't even be a good case for the conflict issue.
Correct. Now, the reason...
But for our purposes now, assume that is a fact, that under Apprendi and Blakely, someone being tried would be entitled to have it found by a jury. Let me take you back to the procedural posture of this case, which ultimately is kind of important to this case. I know we've got these issues out there, but ultimately we have to decide this case. So in July of 2002, that resentencing, where this finding was made by the trial court, became final. The appeal was, the first DCA issued a decision affirming the denial of the Apprendi claim.
Correct.
Been raised.
Correct.
Okay. So after that, insofar as that resentencing, that's over and done with, except to the extent that relief is available in post-conviction land, right?
Yes.
Now, when we moved into post-conviction land, did the state ever say, hey, you can't give this guy relief under Apprendi and Blakely because those are cases that don't have retroactive effect in post-conviction land?
Quite frankly, Your Honor, the state was honestly not invited to the party, and that happens typically, and the defendant wasn't other than the fact that the defendant filed a motion. When these things are raised in 3800s or summarily denied, it is seldom that the state is even asked for a response. The state's position taken below, if there was indeed a Toller order issued, which if you'll give me one moment, I'll look. Yeah, we actually issued a Toller. The Toller order was issued in Isaac 3, and the state indicated that the court was bound by its prior holding as to Apprendi, and the state was the appellee below, not the appellant below. So the state didn't have anything to preserve. That happened.
Well,
actually.
Wait. Okay, you've got a 38. Help me understand this. It's complicated.
Yes.
3800A motion alleging Apprendi error at the resentencing.
Yes.
And that is denied.
Yes.
Say A or B?
I thought it was A. Yeah, because it's all over and done with. It's, the appeal is over. This is all 3800A.
He actually files an amended 3850.
He had earlier 3800B while before the Heggs resentencing was final.
Yes.
That's history at this point.
Yes, but he filed an amended 3850 on June 2nd, 2003. The trial court found that motion was time barred, and as to the Apprendi claims. And so then it comes up on appeal of the summary denial of the 3.850 motion to the First District, and the First District issued the opinion on which we're here today, which found that both Blakeley and Apprendi were
Now,
Blakeley
is then decided after the 3800A motion has been decided, but before the appeal of that, correct?
After the amended 3850 is decided, and I think while it was pending on appeal, because the First District issued an order and required briefing for the first time in 2005, and they don't have in my notes that he requested a belated appeal in this case, so I assume it was a timely appeal at this juncture. I can check the date on the appeal.
I don't think there was a belated appeal here. It's just it's pending there for an extended period of time. But let me ask you that. Okay, when you're in your appeal of the denial of the 30, it's not your appeal, but the defendant's appeal of the denial of his motion for post-conviction relief, however it was framed, that raised the Apprendi issue, then you had an opportunity in the first DCA to say, hey, Apprendi and Blakely don't apply because we're in post-conviction land, right?
Correct, because a Toller order was issued in this case.
Did you do that?
I did not bring the full files over because of the sheer volume of the cases, but what I can tell you from my notes is that it appears that we, at the very least, reference this court, the First District's previous response, finding that Apprendi did not apply.
Okay, so you raised that issue.
At least that much. It may have been more.
But the First District, I want to make sure something about whether, because we certainly have held this you can't apply Apprendi retroactively. That is to sentences that were final before Apprendi was issued, convictions and sentences. Now, there's a live issue here as to whether a resentencing, which is de novo, the defendant has the benefit of Apprendi, or we wouldn't be here on this case. When the court, the sentences, he was resentenced in 2001, did you say? But there was a mandate. It went up on appeal in 2002.
Correct.
Direct appeal.
The mandate was issued sometime. I don't have noted that there was a motion for rehearing, so it would have been issued sometime after July 23rd, 2002. So probably in August 2002, the mandate issued.
The question I have was what were the issues from resentencing? What was raised on appeal and what was raised on... do we know that? Was he pro se?
He was pro se at the time, and it was a summary denial, so I don't have...
A denial of his appeal?
Wait, which appeal? Hold on, let me get to Isaac, too.
The appeal from the resentencing where Apprendi had already been decided.
Correct. He had a public defender there, but it came up in a post-conviction... let's see what we did.
But to be clear, he did, in fact, raise the Apprendi on that appeal.
Yes.
And the court, that's the appeal where the court said Apprendi doesn't apply because he was sentenced within the statutory maximum.
Correct, and the state briefed that. It's not a part of this record. That's
okay,
the pre-appeal.
And in this case, that would end up, we wouldn't then have to really decide anything more other than does Blakeley apply because Blakeley wasn't decided at the time of the resentencing.
Yes.
Okay, so that's the only issue. Apprendi applied you don't agree with that, but the First District said Apprendi applied, but it doesn't give the defendant any relief.
Correct, because at the time the statutory maximum in all federal circuits and before, the courts in Florida meant the statutory maximum under 7.
But we're not here on that decision, are we? That decision was final in the year 2002.
Correct. We're here
we're here on a post-conviction challenge arising from that.
Correct. And none of the federal courts permit a collateral challenge to a final sentence or final conviction. So that's the problem with what the First District did here.
But you have never answered, in my estimation, what Justice Kennedy asked you, which is, at this now proceeding that we are looking at, did the state actually argue that we are now in post-conviction and Blakely and Apprendi do not apply because this man's conviction and sentence are final?
If the state did not argue that, the state was not required to argue that, because all we did, this is a summary denial, there was no briefing required. The state would have only responded to the question asked by the First District, and that would have been the only thing we responded to. And we were, again, the appellee below, so we did not have we don't have a preservation duty where the appellant did. And that's the best I can answer your question. I'd be happy to submit a supplemental brief if I need to go any further.
I do want to add one other procedural question here. We're here on Isaac, what we're calling Isaac 3, a 2005 decision that decided that Blakely was a clarification of Apprendi and it would be a manifest injustice not to apply it, correct?
Yes.
Okay. But subsequently, in Isaac 4, a 2008 decision, they are talking about challenging the denial of a 3.850 motion, and they are now looking at Galendez, and they say it's harmless error beyond a reasonable doubt. What's the status of Isaac 4?
Isaac 4 concluded.
So isn't this moot?
Well, the problem
I know we asked for, listen, I'll take blame, even though it's, blame is part of being on this court, about this additional briefing. But it does seem that we, as Justice Kennedy said, we start out with the issue that at the most we would do in this case, even if we accepted the position of the First District and there wasn't all this procedural problem, we would say it's but they've already decided it's harmless beyond a reasonable doubt.
This is the fundamental problem with that. There is an exception to an exemption to Blakely called the Almendarez-Torres exemption that deals with recidivist-based sentencing. Isaac's sentencing departure reasons are purely recidivist-based. The result of that is neither Blakely nor Apprendi actually apply to his case.
You're giving me another reason. I'm giving you the easiest reason. They've already said under Galendez it's harmless error.
We also need to deal.
If we decide you're wrong on that issue,
you still
Mr. Isaac's still going nowhere, right?
Correct.
So this is really, at this point, this case is purely an academic exercise. We may have jurisdiction over it, but it is nothing but an academic exercise.
And
is that correct?
That's correct. And the state asserts it's an important academic exercise because this is the lead case. This is where the first DCA has drawn its line in the sand and its line in its entire line of opinions.
Well, we have, I guess we'll have a chance in another case to discuss the merits, which is, again, in a case where Apprendi and Blakely were already decided before resentencing that this court has not decided the issue, that would apply on resentencing. And I guess you'll have a chance, if you don't do it on this case, to do it in another case.
Yeah, so the important one here is the importance of Isaac relative to the other cases, because as I said, they each have factual and procedural histories that are very different. Isaac's got purely recidivist-based reasons for resentencing, which should be exempted from the application of Blakely.
Well, but it's about an escalating pattern, right?
Right, which under...
Jump to the substance of that. That is not something you can just look at the record of convictions and as a matter of law determine it. Why isn't that a factual decision that has to be made based on looking at all those things?
It is no more factual than the HFO sentencing, which is exempted from Blakely, It is no more factual than the PRR sentencing that we've already exempted from Blakely. Escalating pattern of criminal conduct under the sentencing code at that time required proximity of the crimes to one another, i.e. the date of conviction, and it required a pattern of those crimes being similar, property and personal crimes.
Similarity in itself is a question that the people can disagree about.
It's an
Obviously,
or.
It's not something where you look at a piece of paper and say, yeah, there it is.
Or it requires
Which isn't, and again, I'll let you.
I'm sorry, Your Honor.
But to explain my concern here, what the court was talking about in creating that exception was something that's already established. I mean, you can look at it and you can see. You can look at a record, and all you've got to do is look at that record and see that conviction is there. This takes some extra steps to reach the conclusion of the escalating pattern. Isn't that correct?
No. The alternative, Your Honor, is that you can look at pattern of escalating criminal activity surely from the conviction itself. You've got misdemeanors to felonies, to third-degree felonies, to second-degree felonies, to first-degree felonies. And if I may reserve the rest of my time for rebuttal.
All right.
May it please the Court, Isaac Ruiz-Cruz here on behalf of the respondent, Mr. Isaac.
I'm assuming you were appointed pro bono.
I was, Your Honor. And the procedural nightmare or headache that's given this Court, I can assure you, has given me more of a headache since I don't do criminal work at all.
It's good you're young.
I still want to address the fundamental issues because I know the Court is going to take the opportunity to address it in subsequent cases, whether or not the Court believes that this case is moot at the end of the day. I think.
Well, but let me just make sure that you agree about the fact that we are in post-conviction land here.
I do agree.
And this is the review of a decision of the First District that reviewed the denial of a post-conviction motion.
That's right.
So what happened in the resentencing itself and what could be brought up there or what applied there is really not the issue that's at stake here. The issue is what can be applied in post-conviction.
That's right, Your Honor. And the state did not, as far as I can tell, raise the issue as the Court posed the question before as to whether or not Blakeley and Apprendi would apply to post-conviction.
What were they asked to do? Now, you know, these summary denials of post-conviction motions are an unusual animal in the appellate world because the appellant doesn't have to file a brief, and the state's involvement in those is sometimes quite limited. So what was the opportunity there that the state was given, and was the state asked to address a particular issue, or what happened?
And frankly, Your Honor, I don't know. We moved to compel the record because the first DCA, since I'm pro bono counsel, to give me a copy of the record, and this Court denied our motion to compel the record being produced because then it subsequently issued the order that Galindez harmless error wouldn't be reviewed.
Right. We decided it was just too
exactly.
hard.
So then we kind of left the record out of it. So then some of these record questions I don't really have perhaps the state does, so they have access to
That's the record in this case.
Well, part of it, Your Honor, yes.
Well, no.
Well,
what I'm talking about would be in the record in this particular case. Not records in earlier cases or other cases. It's the record in this case. And I don't understand why that wouldn't just automatically come up and be part of the record in this case. You have the record in this case, don't you?
I have the record in this case from an appendix that the state attached to their brief because of the First District's reluctance to provide pro bono counsel with copies of the record on appeal. So the answer to your question is I do not have that particular document.
Let's try, Ben, in your time, because we try to select cases that we thought were going to present the issue that we didn't decide in Galindez. So would you state for us what you see the issue to be globally and how you would answer it?
Absolutely.
Because we've already decided Apprendi is not retroactive. And this one, do you agree that under this case they already decided that if your client simply had the benefit of Apprendi, that would not help grant him relief?
That's true. They did not, though. However, the Blakeley issue is still alive, would potentially still be alive, first and foremost. And secondly, I'm not sure that this Court, because obviously it hasn't issued a ruling yet on the Apprendi issue and whether or not it applies to and it comes in conflict with this idea of de novo sentencing. And I think that's going to be, at the end of the day, a choice must be made.
We're not here on the resentencing. We're here on a post-conviction challenge. And that seems to be, you've moved into a different world now. In order for you to prevail here in this case, would we not have to decide that Blakeley is applied retroactively? Or would that even get you relief?
Well, I think it would, but and I did brief the issue of the retroactive application of Blakeley. I do not believe, and this is, I think it hinges on a fundamental issue of federalism. I know that there's been some confusion, at least for me as a practitioner, looking at the retroactivity tests as they've emerged with respect to criminal law from this court versus what the U.S. Supreme Court has done with retroactivity tests. At the very least, the retroactivity test that this court applies must be at least as expansive as the one that the U.S. Supreme Court uses under Teague. In my brief, I went through sort of the Teague analysis of the Blakeley issue, and of course the linchpin question is whether or not a new constitutional rule is being promulgated by the United States Supreme Court. And I went through the Blakeley decision in my brief ad nauseum. I don't need to do it here again, as to why I don't think that Blakeley is announcing a new constitutional rule. I think clearly on its face, it is merely applying Apprendi.
Have any of the federal the federal circuit courts agreed with your view on that?
No, Your Honor. And the U.S. Supreme Court has yet to rule on this particular issue. But I would point out that the Kansas, and I cited to the State v. Gould case out of the Kansas Supreme Court, actually applied, essentially did and conducted the Blakeley analysis to its own state sentencing guidelines after Apprendi but before Blakeley was decided, to show just how obvious it would be to a state court that Apprendi meant what Blakeley said it meant rather than what Apprendi meant.
Well, the problem there, I mean, I'm not sympathetic to that argument. I mean, because in Blakeley, the court talks about our precedents compel this result. But the use of the term statutory maximum in Apprendi really throws a little wrinkle in there, because when you start moving that over in the guidelines, you're really dealing with something that doesn't fit the what would have previously been conceived of as a statutory maximum.
And that might very well be. And if this court is inclined to go down that path, that's why I think it still is clear that it announces, if, assuming arguendo, this court finds that that is the case, that it is in fact announcing a watershed rule of criminal procedure.
Yeah, but it would be hard. I mean, that's where it's hard that if Ring and Apprendi are not retroactive. I mean, when the Supreme Court found that Ring wasn't retroactive, I thought, well, this is, you know, they have announced something that had cataclysmic effects across a lot of states, but that's not retroactive. Apprendi's not retroactive. I don't think you get there on Blakeley being retroactive. But if you're saying that Blakeley is a clarification, then the application of it would have to fit into the manifest injustice exception to the law of the case. Is that what your argument is?
That's right, Your Honor, yes.
That it would, but here, this is hard to apply it because it's already been found subsequently that any error was harmless. So it's kind of become self-defeating as far as
yeah, I mean, I think that the mootness issue would revolve on just the ability of a due process challenge to escape review in this type of a situation. As the state has pointed out, the first DCA.
But you see that Blakeley clearly, and I think, I don't think anyone could argue that we thought they were dealing with a real statutory maximum. But when you read Blakeley, it makes complete sense what they were intending to do that they never said they were doing.
That's right, and perhaps the best way to deal with it in the way that I've briefed it is to revive the rule about the distinction that this court has raised in prior versions of retroactivity tests in the clarifications of the law. If it was merely a clarification of the law, then I think that it could have the effect, just as if it were read to be not a new constitutional rule under Teague.
But wouldn't it fit still in the manifest injustice exception of the law of the case? So that, let's just say hypothetically here, well, maybe not hypothetically. What was your client's original sentence? Do you know that?
It was 20 years, I believe. The main sentence was 20
years.
Okay,
and if he had gotten the benefit of the guidelines sentence post-Heggs, what was his sentence?
The exact number would have been 119.25 months would have been the top of the guideline sentence, so it would have been under 10 years.
So that's a pretty significant difference in the sentence. So if you took something where somebody, could have been sentenced to 50 years, and under the guidelines they'd only have 10 years, and it's clear Blakeley would give them relief, you could make a very compelling argument that it's a manifest injustice not to apply Blakeley, which is different than a retroactive application, is what I'm understanding.
And that's exactly right.
Is that you distinguishing those two?
That's exactly right. And the finer point, too, is that one of the concerns that Justice Cantero had raised with the state's interest in the finality of these things, and the question about whether or not, and this is certainly a concern this court has expressed throughout, is whether or not there's going to be the effect of judges or the state. And I know that we're on post-conviction relief and a collateral review. But the question of whether or not on resentencing the state is coming back and attempting to impose the original sentence that was subsequently found to be illegal for whatever reason. Under the Heggs analysis, the 20-year sentence was inappropriate, so now it should be a maximum of under 10 years. But then, for the first time on a resentencing, the state is, because taking advantage of the fact it's a de novo proceeding, seeking to have a departure sentence and impose, once again, that original sentence that was illegal, essentially.
So they, in fact, they're saying, no, you can't, you got to rely on the conviction. You can't have this tried by a jury. But on the other hand, they're introducing all this evidence to show this upward departure.
That's exactly right. And that's the conflict between having de novo sentencing in the first place and then the issue of whether or not the conviction is going to be final. And I don't think, and I know the court may consider it in another case, so I'd like to just make the argument, I don't think that this turns, as Justice Cantero points out, on the availability of a jury in the resentencing proceeding. Because I think it's very clear that any due process concerns that we have flow from the deprivation of liberty in an enhanced prison sentence.
Why would have courts around the country, that's where they've applied and said Apprendi and Blakely apply, have they convened a jury for something where the state was seeking an enhanced sentence, or do they just say whatever's in the conviction's final, you don't have a second shot before the jury, you couldn't do this at all?
Yeah, it would be the
Well, what would be wrong, I guess, and this is, we couldn't at that point at least come to a definite conclusion, is there a constitutional error in saying where the state is seeking something that maybe they would have been able to seek if Apprendi had been around at that time, that convening a jury to decide that fact would, with both sides able to cross-examine, doesn't violate anything? You're applying Apprendi, but you're just having a limited jury for that purpose. Has any state or any court done that?
Not that I'm aware of.
But do you see any constitutional prohibition?
Well, there could be some double jeopardy concerns in that type of a situation. One thing I would point out, though, with the facts of this case from that situation is that Apprendi had issued before the resentencing, so the state would ostensibly be aware of the fact that Apprendi was out there before the resentencing when it did seek the departure sentence for the first time. And that once again raises the concerns about the motivation to try to reimpose an original sentence that had been subsequently found to be illegal.
But if we're in a resentencing posture, and in this case, Apprendi had come out before the resentencing was complete, what's wrong with the state, since resentencing is a new procedure, what's wrong with the state having an opportunity to do the upward departure? Your client has the opportunity to argue his Apprendi issue, so why doesn't it give both of them like a new playing field here?
Well, what's wrong with it is that the rights that are found in Apprendi and subsequently explained in Blakeley were not fully available. The full panoply of rights that Justice Cantero talks about when you have de novo sentencing, when you have the due process rights that are implicated by the potential loss of liberty, weren't there because a new jury wasn't reconvened for the purpose of determining the enhancement, in this case, the idea of the constant or escalating pattern of violence throughout his history.
That whole notion of a new jury being convened, I mean, how far down the line do you go? You almost end up retrying this case, and I think I would have some real serious issues with that.
Well, I think what it fundamentally does is that it forces the state to seek the departure sentence for the first time when if it has its best cards or its best hand, so to speak, to put its best hand forward at its first opportunity for sentencing.
So you're saying no, you don't think there should be a jury convened for a specific purpose. If the state can't prove it based on what already is in the record,
that's exactly
found
right.
by the jury.
But
that's exactly right.
But you said that it might raise double jeopardy concerns. Do you have any authority that supports that conclusion or suggestion that there would be a legal impediment to impaneling a jury in circumstances where there's going to be a resentencing? Now, that's not the circumstance here, but in circumstances where there was going to be a resentencing and the defendant said, "Hey, you can't do that without a jury," and then the state says, "Well, bring the jury on." And you think, tell me what specifically you know of that's authority that would say that could not be done. The state, when they said bring the jury on, the court would say, no, you can't do it because.
Unfortunately, I'm not aware of any authority that is going to that point. It's merely, as we contemplate, this is new ground, I think, pioneering ground for both the states and for the federal courts. So we're just left with our thinking about what the Constitution means and seeing where we go from there. And I think it might impinge on some rights, given that a prior jury was already impaneled and determined certain. Essentially, if we apply.
If we really say it's a de novo if it's de novo for purposes of the sentencing, I mean, we impanel juries all the time. Not all the time, but with some frequency, we have impaneled new juries for resentencing in capital cases. So if we can do it there, why couldn't we do it in this context? Are you suggesting that those proceedings are illegal?
No, Your Honor.
That's actually an I had forgotten that one, and that's really, we do say de novo, and they can seek aggravating circumstances that they didn't seek before, but it's found by a jury.
That's right. The fundamental, what this pushes, what Apprendi and Blakely really forced the state courts to do and is forcing this court to do, is reevaluate the idea of de novo sentencing, really. Because if de novo sentencing means truly de novo sentencing, that the state will have the opportunity, and really it's going to be the state, to present additional evidence and, like in this case, seek a departure sentence for the first time, then the Apprendi and Blakely rights of having a jury there are really implicated.
So if the defendant then would be able to exercise those rights, but they couldn't say you can't present it for the first time unless we change what de novo sentencing is.
That's exactly right.
I just want to make sure, going back to what Justice Caney's original question was about the Blakely interpretation. The First District, I now realize as I'm reading it, is that if there's a clarification of a law that by not applying it would result in a manifest injustice, we have allowed successive attempts to show the court that there was a manifest injustice. In those cases, we're not, again, and maybe you've said this, I just want to make sure, we're not dealing with the retroactive application of a statute in a traditional sense of it just applies to every case that has previously been final. We're looking at the specific facts of a case and seeing whether in that case a manifest injustice would apply by misapplying what Apprendi meant to say as clarified in Blakely.
That's exactly right. And that's why this case may not in and of itself be moot for review.
Well, but let me try to understand that. Because we're here in post-conviction. And is that basically... I mean, I'm not sure I understand what law of the case has to do in post-conviction, because that's final. Okay, we've got a conviction and a sentence that are final. And it seems like to me what we're talking about here is retroactive application. It's not manifest injustice or any other thing like that. Now, whatever you're going to decide, whether you're going to give it retroactive application, because the whole question when we look at retroactivity under Teague or Witt is whether the case that announces a new rule is going to be available on conviction and post-conviction proceedings, right?
Yes, but it necessarily implicates the law of the case doctrine. I'm not sure how you can get away from the law of the case doctrine there. And that is what would give essentially the finality to...
Well, I thought law of the case is a doctrine that comes into play before, in a case while proceedings are ongoing.
In the appeal, yes, Your Honor.
Right, but before it's final. Isn't that correct?
But that's what it is. The law of the end of the law of the case doctrine is the idea of finality in that first appeal, and that's why I think that we can discuss it in post-conviction land, as Justice Pariente has pointed out.
I'm not sure. I asked you to clarify your argument. That's how I understand it. That's how I understand the First District applied it here.
Justice Pariente is certainly right. They talk about it, but it seems like a category mistake. They're talking about something that doesn't really fit over in this post-conviction world that we're actually in this case. Because maybe I'm forgetting what law of the case is, but I thought that was something that where you've got proceedings that are ongoing, but there's been an interlocutory appellate decision on something in that case. Well, that's done unless there's some good reason to undo it. We're beyond that. This is final. So I don't see how law of the case comes up after the case is final.
Law of the case is but manifest injustice, like Fiore versus, I think it's Fiore.
It is Fiore versus White. That's right. And that's where, and I think that's what's springing really the first DCA's analysis here is the Fiore versus White case with respect to that. So if this court were to find that this is not moot, I think the real question is the evaluation between, and I'll wrap up very quickly, the evaluation of de novo sentencing versus the idea of Apprendi and Blakely applying at that sentencing proceeding. Thank you.
You have about a minute and a half to wrap up.
Yes, Your Honor. I'll answer Justice Kennedy's question. I did review the record regarding what the first DCA requested, but I just wanted to point out that the state did put its best foot forward under the facts of the case as they existed at the time he was sentenced. The guidelines were found to be unconstitutional as a violation of the single subject rule. So the state put its best case on under the law as it existed.
Are you talking about in this case or the earlier case?
In 1995. We put the best we could forward.
Does that have anything to do with the
and that's why. But that's why when we get to this later date and time, the state then had to ask for a departure to keep Mr. Isaac in custody for the originally intended sentence. Alaska applied the Stovall link letter test, which is their state test, which is basically our WIT analysis, and reached the conclusion that Blakeley should not be applied retroactively. Every federal court that has addressed the claim on collateral relief has found that it should not be applied retroactively. And all of the federal...
A quick question in the remaining time. Maybe I asked you this, but explain to me how, if we had stayed this case, how the First District came at the subsequent decision. The state was...
Your Honor, we moved below, the state actually moved below to stay the court to actually stay the issuance of the mandate on the Isaac 4 appeal, and it was denied. I mean, the state went to extreme efforts and actually alerted opposing counsel to that in an attempt to stop that from happening. And if Your Honor look at...
But if this case was stayed, what subsequent case was there?
Your Honor, what had happened is the first DCA did not stay the issuance of the mandate on its Isaac 3 appeal, and this court apparently did not, and I didn't catch it. This is apparently the only one it happened in. This court did not stay the mandate in Isaac 3 from the district court. So it went back down on Isaac 3 and finished its proceedings on Isaac 3 and then came back up.
Okay. That at least, I thought we had stayed. That's at least explained.
I think that's the best thing explained. And, Your Honor, the Toller order is at Exhibit O of the state's appendix.
Well, thank you both for your arguments. The court will now take its morning recess for 10 minutes. Please rise. Next case, State versus McGriff.
May it please the court, counsel, Christine Gard on behalf of the state of Florida. Again, I just want to walk through a little bit of the procedural history for McGriff because he is in a different posture than the other defendants that are here today. Mr. McGriff was charged in 1987 with a homicide. He was convicted in 1988. His direct appeal became final when the mandate issued after the order denying rehearing on January 4th, 1990. He had two subsequent appellate proceedings in 93 and 97 prior to the decision in Apprendi.
And what was his sentence?
He was sentenced to life imprisonment on the homicide, which is second-degree murder with a firearm. There were other counts also attendant with the crime, an armed burglary and an armed robbery. Then in 2000, post-Apprendi, there was an issue involving his HFO designation that appeared on his sentence. He was resentenced, removing that designation. The state appealed that because he wasn't present. Mr. McGriff was granted a belated appeal to challenge his presence at the sentencing proceeding. And during that time, which was May 23, 2003, the court granted a 3800B2 motion. And he was resentenced June 20th, 2003, simply removing the HFO designation, doing nothing else. Everything else was identical to the past proceedings. He appealed, and his appeal became final sometime after September 29th, 2004, which is after Blakeley, but also after that mandate issued following that September 29th, 2004 decision. He did not raise Apprendi or Blakeley in that process of that appeal. So we're here now on a 3800A motion filed November 9th, 2004, and an amended 3800A motion filed July 5th, 2005, which were denied January 6, 2005. And in McGriff 7, the First District applied Isaac to McGriff's sentence. So that's the procedural posture right here.
So how is this different than Isaac? I mean, I understand different things happen along the way, but in terms of the procedural posture we're in now, putting aside the fact that you've had that subsequent Isaac 4, how is this different from the procedural posture of Isaac 3?
The state would assert that realistically a de novo resentencing didn't occur in this case because it was a ministerial action removing the HFO designation from the sentence many years after the sentence was imposed. And it should have been handled in a ministerial way. It was instead subjective to sentencing.
Okay.
But there was
it was called a resentencing.
But whatever happened there was final back in on September 29th, 2004, right?
Correct. Or shortly thereafter.
Or thereabouts.
Yes.
Okay? And so what we are actually here on now, as we were in Isaac, is to review a decision of the First District which reviewed the denial of a 3800 motion.
Correct. It is.
So we're in post-conviction land.
Yes, correct. And as the state asserted before, Blakeley has not been applied collaterally by the federal courts. And I believe the Alaska court in its recent decision found that it wouldn't be retroactive on collateral proceedings as well. Those cases are all cited in our brief and referenced in our brief.
So there was, I thought, and I have to now go back through, I was looking at all three together, that the resentencing in this case occurred before Apprendi and the sentence was still on appeal when Blakeley was issued. Is that not the case?
It is not, Your Honor. He was resentenced June 20th, 2003, removing the HFO designation.
Well, is that an issue as to whether that's a resentence? That's a separate issue.
Right. The state has asserted that that's just a ministerial action, so he shouldn't be entitled to.
The court must have, in going further on briefing, to have you brief the Blakeley and Apprendi, must not have either agreed with it or just, because otherwise that would not make this in conflict with anything, right? Whether there's actually a resentencing.
Well, again, the court in the First District applied to this case. Therefore, it's in conflict with the rest of the districts.
Well, did they? Yeah, but on the first issue first there has to be a resentencing. I mean, even under well, the way I look at this. I mean, let me be clear how I look at this. I look at this that if there's a resentencing, it's de novo, and if Blakely and Apprendi were at that time, that the defendant gets the benefit. But I don't see a reason why the state, if they're trying to prove something that hasn't been previously proved, just like in full cases, there can't be a jury trial if that's what the defendant wants on that issue. That's where I would be. Now, whether we get there in any of these cases, so if the other appellate courts have been holding it differently, then, one time, whether it's today or 5 years from now, that issue has to be resolved. Let's go, but on this case, you're saying that no resentencing ever occurred, so we'd only get to the issue as to whether somehow Blakely would be retroactive, but it would still, to where? I mean, it would still have to be, you're saying it's back to a sentence that occurred back in the 90s.
Well, our argument is that Blakely should never, I understand what Your Honor's position is. Our argument is, first of all, Blakely nor Apprendi should ever have been applied because it was a ministerial action and not a resentencing. So assuming this court rejects the state's position with respect to the HFO designation being removed and finds that it is a resentencing, then the First District applied Blakely after the resentencing again became final on its resentencing direct appeal. Now, this conviction was final in 1990. So now we have Blakely and Isaac being applied to a decision from 1990. It's now 23 years old. So at that,
you've got a lot of different arguments here. I understand that, but isn't the simplest and most obvious way to look at this case is, as I pointed out before, we're in post-conviction land here, and Apprendi, we've held that Apprendi doesn't apply, and if Blakely doesn't apply, then they don't apply.
Yes, Your Honor, and if I was certain that the rest of the justices on the court took that opinion, I would sit down and go home now with respect to this case.
But let me ask you about the 2003 resentencing, which you referred to as simply ministerial. If, in fact, at this hearing, they had done what they did in Isaac, which is say, okay, we can't have, in Isaac it involved a Hague's issue, but in this case, okay, we can't have the habitual offender designation anymore, but Judge, let me tell you why you could exceed the guidelines or whatever else they could do. Would that be a resentencing?
I think arguably that would be a resentencing, and the question is how this court applies Blakely and Apprendi to that.
Okay,
but here,
all right. So if, in fact, that was a resentencing and that kind of situation had taken place and Apprendi had come out 3 years before, Apprendi would be applicable. Would you concede that Apprendi would be applicable to that kind of proceeding?
No, Your Honor, because in this case, the state asserts that the conviction date is what controls.
So
and
you still go back. You still maintain that it's the conviction date and not the sentencing date that we are dealing with.
Yes, I take that language from this court's opinion in Hughes.
And that language says specifically what?
This court in Hughes stated that this court had achieved an interest in finality of the sentence at the time the conviction became a final on direct appeal.
A finality of the sentence.
In Hughes, they separated conviction and sentence.
Okay.
And they say the state acquired its interest in finality of the conviction at the time the direct appeal became final.
Okay.
So, in other words, Mr. McGriff's conviction became final sometime around January 4th, 1990. And as a result, that's when the state acquired its interest in the finality of this. That's when the state last had the chance to put this information before the jury that had been impaneled already in McGriff and obtain the ruling.
Let me ask you this. Do you see any constitutional impediment to impaneling a jury in a resentencing proceeding if the Constitution requires that certain facts be found by a jury in order for that sentence to be enhanced?
I have watched the arguments in Galindez, and then obviously I was here for Isaac this morning. And each time this argument is presented by, well, I guess it's been the respondent both times, by the defendant, there is always some kind of double jeopardy attack raised. Now, I don't know.
But nobody's, that's just thrown out there as just kind of like maybe something that'll stick. There's been no support for it. And
No.
Can you think of any reason that there would be a double jeopardy problem in this context, or any other sort of problem in this context, if we permissibly impanel juries for resentencings in death cases?
No, I don't, given what we do in death cases. But I can't, again, you know, the other issue hasn't been briefed.
You would rather not have to go there.
Correct.
You don't want to have to impanel the jury because you want to get it to stick without that. But you know of no impediment to impaneling a jury.
I do not, off the top of my head. I have seen the argument made twice in preceding cases, and I assume it'll be made again here. The other thing that I will assert to the court is that this case is, again, 23 years old today, or in the vicinity of today. It's actually more than 23 years old. So the state now has a huge impediment of being able to prove any of these things up because we don't have live witnesses to present to a jury potentially. It's really hard to know who's still alive from the police force over in Quincy at the time this case was done. It's hard to know what experts we have available. That's why there has to be a finality point, and that's why I think the Hughes Court and why the state asserts that the conviction is controlling here. The error, Blakeley and Apprendi error, occurs at the time of trial. It may become manifest during the sentencing process, but it actually occurs during the term of the jury trial.
Again, putting aside the actual posture of this case and that we are in post-conviction land, if we were just dealing with a resentencing directly here, we're on direct appeal from a resentencing, isn't it the case that this court has time and time again referred to resentencing proceedings as de novo proceedings? How do you get around that? I understand you've got Shull or some case, but isn't that a tiny little exception that in this context can't be allowed to turn the whole rule around, can it?
Well, it's a tiny little exception, but it is a true exception to the rule. So it is not true that all sentencing proceedings in Florida are de novo. That's the point of the state's argument in that particular case.
For some reason in that case, this court decided to carve out a little exception. But you admit, don't you, that the basic fundamental rule is that resentencing proceedings are de novo, right?
Yes.
Is that the truth?
Yes.
Yeah, and again, in Isaac, in the last case, the state actually offered a reason that was never, that to the defendant's detriment, that had never been argued before because it wasn't necessary.
But again, in Isaac, I believe that the state's position is that because of the specific findings of the trial judge there, the escalating pattern of criminal conduct, as it's laid out in the departure order, is misdemeanor to felony of the third degree to second degree to first degree.
So that it still is that the defendant sought the benefit of, the state sought the benefit of something that would increase the sentence substantially.
Well, typically in these kinds of cases, what happens is the defendant is seeking.
Can you say
yes? Yes, I'm sorry, Your Honor. But what happens in these cases is that the defendant is attempting to seek a benefit also. It's not just a state benefit.
Well, we understand when someone's being sentenced to either life imprisonment, 50 years, 40 years, and they can cut 10 years off of their sentence because there's been a change of law that benefits them. Do we really... that's not a frivolous argument.
Oh, no, and I wasn't suggesting it was frivolous. What I was suggesting is that because they get that opportunity, sometimes, when you roll the dice, sometimes you win, sometimes you lose. In some of these cases, the defendant will lose because the judge is able to find those other reasons, or because they were previously found. Like in McGriff, the departure reasons are the original departure reasons, and one of the departure reasons in McGriff is also that pattern of criminal conduct, and it's spelled out in the state's briefs.
And in that context, some of them are not, however, reasons that are a prior record, correct?
Correct.
So those are the kinds of things that you would have to have a jury determination on. Is there any law about if some of the reasons are proper and some are not?
Yes, we only need one reason to remain as proper in order to preserve the sentence, particularly in these kinds of cases. That may not always be true, but in this type of case where the aggravators are primarily recidivists, the only other aggravator in this case was the secreting of the body, which he hid, which
Wasn't there
could be
something about he
reduced.
wasn't amenable to rehabilitation?
Yeah, it was based on his prior record was the finding. And if you read what the trial, but you have to read what the trial judge finds and the findings, not just what the preamble says that it fits under in terms of under the guidelines, we had certain categories that they could find under. And it depends on what the trial judge says with respect to those categories, whether it's going to be recidivist or it's not going to be recidivist. I agree with the court on that point. There are times when amenable to rehabilitation might only be based on one prior charge, and then you wouldn't have an escalating pattern. You wouldn't have a recidivist-based sentence.
Let me ask a question, just practical for the administration of justice in this state. All the other 4 districts have held that if the conviction and original sentence were final before Apprendi, that resentencing, they don't get the benefit of Apprendi and Blakely. Is that correct?
That's correct. Or they found that Blakely, if it happened under Apprendi, they found the same thing for the Blakely application alone.
What is there? Are there cases then? I mean, what I'm concerned about is that if this court, if we can't reach that issue in any of these 3 cases, we have a situation where this conflict, which is whether it applies, is going to continue in all those courts. And then the question is if we decide that should have been applied, is our decision done 5 years later going to be retroactive? And in the meantime, we're having these resentencings. I don't know how many occur, where the state's taking the position that Blakely or Apprendi do not apply. Has that been happening in all the other districts?
That's my understanding. I'm not certain what happened specifically on the ones you remanded. I assume a number of those were disposed of by Galinda as harmless error.
We must have, if we remanded them, we must have thought there was another basis to approve.
Correct. And the bigger problem is, if Your Honor recollects, the number of Heggs cases that have been subjected to resentencing is huge. We have those open. We have any time an HFO gets stricken off of a potential sentencing document that we're going to be able to do this if we allow collateral challenge.
Well, now you're talking, though, about a very narrow issue that I'm somewhat sympathetic to, which is whether striking an HFO designation is a resentencing. The first district seems to just assume it was, correct?
Correct.
So you think that issue about whether it's just striking a designation is really what we talk about a resentencing needs to be, that's another basis to see a problem in this case from the state's point of view.
Yes. And
let me just ask you on that point.
Yes, ma'am.
What, maybe you don't know how the Department of Correction even uses these kinds of things, but it seems to me that while you might say it's ministerial, it probably does have some effect on what's going to happen down the line when it comes to whether or not what is going to be his parole, maybe they don't have controlled release eligibility and those kinds of things.
Obviously, an HFO sentence affects things like gain time, but so do the gain time rules. So it's really hard to know or to say, for instance, a PRR sentence or a day-for-day sentence, things like that, mandatory minimums and things like that. Those are all going to affect if we undermine those sentences or strike that sentence. Obviously, his release date is going to be sooner. This gentleman,
for example, if credit for time served, if that becomes an issue and it's remanded to correct credit for time served, is someone asserting that's a resentencing that would open everything else up?
I don't know, Your Honor.
But that's
the question.
Rule would be much greater than just Apprendi and
potentially, yes. And that's one of the state's other concerns, and why the state asserts it should not be found to be retro.
The state has never tried to argue. I mean, in that situation, if the state tried to get a greater sentence, that would be a double jeopardy issue. So really,
purely.
It can only apply Apprendi and Blakely in true resentencing, where everything gets opened up, where the state gets a chance to argue for a harsher sentence, it seems to me.
Correct. And in this case, again, I just want to point out he did receive a life sentence, and it's a natural life sentence. With that, I'll reserve the rest of my time for rebuttal.
Good morning, and may it please the Court. I'm John Mills on behalf of Mr. McGriff.
Did you know what you were getting into when you...
I did. I do enough of these that I knew it, and I groaned when I got it. But I'm very happy to be here. And I do think this is the case where you can decide this very important issue. There clearly is a conflict among the districts. We don't have a mootness issue. The last case you heard seems to me to be moot. This case is not moot. And I would really like to focus my argument on two procedural aspects that I think are being lost here. The first is that this was a resentencing. And the second is, Justice Kennedy, while this may reside in post-conviction land, there are two territories there. And where it is, we're safe. I'll get to that in a minute if I could. This is a resentencing. This case involved a resentencing, at least from what we can tell on the record.
That's sort of my concern. Is that a live issue as to whether what happened below was, quote, just simply removing the HFO designation, or was...
It's an unresolved issue that no court has been presented that argument with until now. The state did file a response in the circuit court. They didn't raise it. They filed a response in the DCA. They didn't raise it.
They didn't raise that it wasn't a resentencing?
No, they didn't at all. They're still free to. All the first DCA said was Blakely and Apprendi apply to cases where the resentencing was not final when Blakely was decided. So they can go back and they can make those arguments. But we have a very limited record. Under 9.141, all we are allowed to have in the record in this case is the post-conviction motion, response, order. There were no motions for rehearing. There were no attachments. So that's the record. However, from that record, I think you can glean why they may not have raised this argument that it was a resentencing. When the HFO came up... That it was not a resentencing. The HFO came up on a 3-800 motion. And there was an appeal, and the first DCA reversed for consideration of a 3.800 motion to argue that the HFO said go to the circuit court and argue that the HFO doesn't apply. It went back down. The circuit court entered an order, said the HFO doesn't apply, and I'm entering the same sentence. There was no resentencing. He just did it. Nobody was there. The state wasn't there. There wasn't anything. And the state appealed that. The state appealed it because they weren't advised, because it wasn't... we don't know why. The record doesn't say, but we know they appealed. First District dismissed that appeal because that's not an order the state can appeal.
They said both... I don't know. The opinion says both parties appealed.
Right. The state appealed, and then the defendant woke up and said, uh-oh, Mr. McGriff said, I better appeal. And he filed a belated appeal, which was accepted. And then it went back down, and the trial judge on his own said... I am going to resentence, and I'm going to have a resentencing hearing, and the state's invited and the defense is invited, and they had a hearing, and at that hearing there was a decision to reimpose the same sentence. And then that went up on direct appeal. While that was on direct appeal, before that mandate issued, was when Blakeley was decided. So Blakeley, this is different than the first case. You don't have to worry about the interim period between Blakeley and Apprendi. This is a case that did not become the sentence, did not become final until both Apprendi and Blakeley had been decided.
But
we're in post-conviction land.
But then, yes, I know I'm like a dog on a bone, but I come back to
let me explain why.
Overarching reality. But that sentence became final back in 2004, and then we moved into post-conviction land. And why is it that Apprendi and Blakeley can be applied to give relief in this post-conviction proceeding?
Because this is not a retroactive application. Post-conviction land, as you've called it, has two territories, if you will. One territory, one area where you're saying, I want relief based on this decision that came down after my case was final. I want relief based on that. That's retroactive. You can't do it in Apprendi, probably can't do it in Blakeley either. But that's not this case. This is a case where the post-conviction motion says, at the time the sentence became final, it was illegal under existing law.
Okay. Where is this description of the two different territories, post-conviction land, set forth in our case law?
It's not set forth in your case law, but all of the cases...
Where is it set forth in anybody's case law?
I don't think it's set forth in anybody's case law.
So this is a novel idea you're presenting to us?
No, it's not.
Well, if it's not in the case law, why is it not a novel idea?
Because it doesn't happen very often. And what all of the cases that talk about retroactivity, this court's cases, the federal cases that I've seen, are cases where you're seeking to apply a case that was not the law of the land at the time the conviction became final. That's what retroactive means. Here, at the time his sentence became final, Blakeley was the law of the land, and his sentence violated the existing law of the land.
Is this correct? This is what
bring
they've
it up?
said. Appellant, this decision says, appellant was resentenced on June 20th, 2003, after the Supreme Court's decision in Apprendi.
Right.
Further, on June 24th, 2005, while appellant's appeal of his new sentence was pending and not yet final, the Supreme Court decided Blakeley.
Right.
Now, so they're talking about an appeal of the new sentence, but then they say in the last paragraph, we therefore reverse the summary denial of his motion for post-conviction relief. But it wasn't really, it was an appeal, wasn't it an appeal from the resentencing?
Yes, that appeal was affirmed erroneously. It was affirmed in violation of Blakeley.
The point you made is that Blakeley was the law then.
Right.
Well, under our notions about about finality of judgments and what happens as conviction land, wasn't that something that had to be brought up? Now, maybe there's an ineffective assistance claim.
Sure. I think there is an appellate ineffective assistance claim.
Okay, there may be an appellate ineffective assistance claim. That sends us off down a different route, and there are different standards that apply. But why isn't this subject to the rule that you can't bring up something on post-conviction that you could have brought up in your direct appeal?
It may be that has not been developed, and that may be an argument that the state can develop back at the circuit court. But we have, they keep talking about this being a 3-800 motion, and he did, Mr. McGriff's pro se motion said it's 3-850 or 3-800.
I don't understand what, I don't understand what has to be developed. Maybe I'm missing something, but I don't understand what has to be developed. Blakeley was the law. Right. The appeal is going on. Somebody can step forward and say, Blakeley.
You can,
but they didn't do so.
You can use 3-850, which has to be filed within 2 years of when it becomes final, to raise any constitutional error in your sentence. If you raised it before or should have raised it before and it was affirmed, you may have law of the case issues. And there is a law of the case issue in this case. But the law of the case was established by the first DCA's opinion that was directly contrary to Blakeley. Now, they didn't know because nobody bothered to tell them a week before they decided it that Blakeley had come out.
I don't understand why that doesn't just throw us then into ineffective assistance of appellate counsel land.
It might, and you still have to answer that same question.
Rather than here, I'm just saying we're going to come in on post-conviction and retroactively apply that decision.
You're not retroactively applying it. You are saying that it applied at that time. We're not going back in time.
I understand the distinction, but it would be helpful if we had some authority that supported that distinction. And I kind of looked for it, and I couldn't find it.
Well, isn't
right.
I'm sorry. Yes, please answer.
Could you find, because I was not able to find a case that applies the retroactivity analysis other than these DCA opinions that have no analysis whatsoever of the de novo proceedings of the thing we're talking about. I haven't found a case in the country that applies the retroactivity analysis here, and I may have missed it. But I think maybe I am. Maybe it is I'm arguing something that hasn't been thought of before, but I think it's pretty clear.
Well, I thought that the way you go is that if a decision is final and at a point where a decision comes out afterwards, it would markedly clarify something that if the court knew about it, there would be a whole different results. That goes into the Fiore versus White, very narrow due process exception. So it's not where it's a clarification of earlier law.
Right.
And that's been very, very narrowly applied because we had I can't remember the case, but it was about what a knife was and whether that was clarified. So that's it's not called retroactivity, but it's a very narrow exception. But here, if the defense lawyer on appeal, was there a lawyer?
I don't even know. It's not in the record.
I mean, so it could just be that this guy was...
I don't think it's clear that the state...
I mean, probably not, because, as you said, the resentencing was never a true resentencing, which was what his error was.
No, I think it was a true resentencing. It originally wasn't.
He might not have been appointed counsel because they said both sides appealed, and I suspect there wouldn't have been a lawyer. Plus, the time that it's final is already run, hasn't it? I mean, you'd have 2 years from the date, assuming there was a lawyer.
Yeah, you have 2 years from the date the mandate issues from the direct appeal. And at that, he's within that. He's within less than a year of that.
But he hasn't raised appellate ineffective assistance because I bet you there was no appellate lawyer.
That could be, and he didn't raise that he didn't have a lawyer because he's pro se and he doesn't understand any of those things. But those were the arguments certainly that I would have made.
Isn't that an issue that it just needs to be brought up in the direct appeal?
I think respectfully, these are all issues that need to be brought up in front of the circuit judge for the first instance. This court, through its briefing orders, I successfully moved to strike their initial brief because they're making arguments that this is a very important issue. The districts are very split. It affects a lot of cases. And you need to decide this issue. It may be the case that at the end of the day, Julius McGriff can't win because he didn't raise the right argument on appeal. He didn't have a wide variety of reasons. But I haven't briefed those to you. And the reason I didn't brief it to you was because the circuit court never heard about it. The DCA never heard about it. You issued an order saying brief this issue of whether Blakeley and Apprendi apply. The state defied that order, added these things in. I moved to strike, respectfully saying, you've said don't do that. Make them do that. And you entered an order striking those, telling them not to do it, and they did it again. And now we're up here and we're arguing things that weren't decided in this case. And respectfully, you're the Supreme Court of Florida. You should decide this issue that's up to you. If there are other things, there's an avenue for them to be decided, and they'll never get to you. They're easy issues.
But you would agree we should only decide an issue that's actually presented by the case before us.
Correct.
So to the extent that there are issues that need to be decided that aren't actually presented by this case, that may be unfortunate, but we just got to wait till a case actually presents the issue.
Well, I think this presents the issue. I think you can find ways in any given case. Galindez, the whole world was waiting to see, and then you disappointed us all because as you're entitled to do.
I wasn't here.
The court. As you're entitled to do, and you should not reach out to decide unnecessary.
Three of us are here.
It was Galindez, and it's really because Galindez was actually, I think, I was trying to look at it, was actually in a good procedural posture.
He was on direct appeal, I believe. And Mr. Fleming, who you get next, is on direct appeal.
Okay, so we might actually have a chance to...
Well, let me ask a question. I wasn't here. I'm a little befuddled by all of this.
Disclaimers.
But in this McGriff opinion, it says the trial court vacated the sentence.
Yep.
Now, doesn't that mean if it's vacated, it becomes de novo as of that date?
Yes, sir. So, I think that's very clear.
So how does that become ministerial?
It's not ministerial at all. I think if it were ministerial, the state wouldn't have appealed it. I think the state recognized, oops, we got a fundamental error here. We had a judge vacate a sentence and resentence without anybody there. That's wrong. They filed an appeal. It was dismissed because they can't appeal it. The defense said, oops, we were supposed to appeal that and did. And while the appeal was pending, the trial judge recognized his error and granted the 3,800, I'm sure it was a B motion, which ended the appeal. And he came and he had a new sentencing proceeding. So there was a resentencing here. There was a de novo resentencing. And if I'm wrong and the record ultimately discloses it wasn't exactly like that, I mean, I'm going off of a pro se motion right now. But that can all be developed. And the important point here is you guys, you just really need to decide the issue.
So what is the issue we need to decide?
The issue you need to decide is when a sentence is thrown out. 3.800 Florida law has long said there is no finality to an illegal sentence. It can be raised at any time. So when an illegal sentence is thrown out, you're going to have a new sentencing proceeding. And the question you need to decide is, at that new sentencing proceeding, are we going to comply with existing law, or are we going to ignore existing law because it wasn't in place back when the conviction was there?
It seems like that's an issue you deal with on the direct appeal from the sentencing proceeding.
The resentencing
proceeding.
It should have been. I certainly would have raised it then.
We're not here on that. We're on a post-conviction challenge, and you've raised an issue
right.
about
well,
that.
We're on a
that's not the issue. The issue you've described about what can appropriately happen in the resentencing is not actually before us, because we're not here on a resentencing.
I think you're here on the question, there's a motion that's been filed under...
We're here on a case.
You're here on a case. You're correct. You're here on a case that got back into the court system on a 3850 motion that said I'm serving an illegal sentence because I was sentenced based on facts that weren't determined by a judge or a jury, and at the time I was done, the law required that that be the case.
Oh, so it's your position that any Apprendi error or any Blakely error renders the sentence illegal. So all those sentences of all those people are set up for grabs.
It's illegal in the sense of if it was...
Why is it illegal in the sense of 3800A?
No.
Okay, well, I don't know what...
In the sense of 3850. 3800A is very narrow. We've come up with the 3 categories that can be raised at any time. I don't have to sit here and argue. I'm not conceding that it's not. But whether this would fall under 3800A or not is not an issue in this case. This is a 3850 motion that was timely. And you can assert the illegal sentence issue in those. What you can't assert is retroactively apply a case that wasn't the law when the underlying case became final.
So your argument really is that this is an illegal sentence because at the time of the resentencing and the appeal thereof, that Blakely and Apprendi was the law, and he was not sentenced according to that law.
That's absolutely
correct. That's the basis of your illegal sentence argument.
That's absolutely correct.
And that 3850 was filed within 2 years of the time that the appeal from the resentencing was final?
Yeah, I've got the dates right here.
I mean,
2005.
The first DCA issued its mandate in October of 2004. The amended motion, he filed another motion I haven't seen, but even the amended motion was filed in June of 2005. So we're within 8 months of when it became final. The amended motion was filed.
And that amended motion alleged that the trial court and the appellate court erred by not applying Blakely?
Yes. The amended motion, yes. The amended motion
but
said...
Blakely was the law at the time that the resentencing occurred?
That's correct.
If it was a resentencing.
Well, at the time that the resentencing became final, I mean, the trial judge didn't have the benefit of Blakely. Probably the first DCA didn't when they wrote the opinion and made the decision, by the time it got out. But before they rendered their decision, before they issued their mandate, it did come out. And if I were drafting this would have been, I would have filed it in the first DCA as a petition for habeas corpus, ineffective appellate counsel for not saying Blakely right when it came out. But I didn't do it. And respectfully, Justice Kennedy, I get where you're coming from. But I moved to strike the state's arguments they didn't raise below, and now this is an argument that even all the ones that the states made, they're not making it now.
I will be the first to say the procedural posture of all of this is rather ugly.
Yeah. Well, and I'm standing up here telling you that I think you need to decide this issue, and I think you do. But I have also filed a motion that you shouldn't decide this issue in our case, because of all the time that's been wasted, because the state just directly disobeyed a very clear order of this court. And in your notice for oral argument, you said you wanted to hear argument on that motion. And
if you had your druthers, what's the relief you would seek for your client?
I think either way, either a dismissal or an approval of the first DCA's decision, either way what happens is the first DCA's mandate is no longer stayed. It was stayed in this case. And it goes back to a circuit judge in Quincy, and the state is going to respond, and they can make whatever arguments they want to make, that it wasn't really a resentencing, that there's Galinda's harmless error, that this is an Alamin-Torres case.
The district court said, send this back. You need a resentencing where Apprendi and Blakely are applicable.
No, they didn't even do that. They sent it back saying, under 9.141, the appellate court's job in a summary denial of post-conviction relief is extremely narrow. The rule says, unless the record, and the record is just the order and attachments, motion and response, unless the record shows conclusively that the appellant is entitled to no relief, the order shall be reversed and the cause remanded for an evidentiary hearing or other appropriate relief. So the only issue, the only reason this trial judge denied the motion was erroneous. And so that basis does not support its ruling. So it goes back, And they can fight about all of these things. And Mr. McGriff, I promise you, will be asking to amend his post-conviction motion to state more clearly what some of his rights were. And there may be an ineffective assistance claim, and that may come into, there's lots of legal issues of whether that relates back, of whether there's a lot of discretionary. There's lots of stuff that goes on before we get to these issues, and I think it would be appropriate for you to address those issues in this case.
Thank you very much.
Thank you.
Appreciate it. Any rebuttal?
Yes, Your Honor. With respect to the motion that was filed by counsel, just to be clear, the counsel in this case moved specifically to strike two portions of the state's brief because it referred to the supplemental record which this court had granted at the time. He then renewed his motion to strike the supplemental record. The record was struck. The state removed all portions of its brief which referenced that offending, what is now offending material. We removed all of it. The state is free to argue in an appeal the issues that it thinks are the important issues to be raised. This court requested briefing initially on two specific issues, the Galinda's harmless error analysis, which it has since receded from, and the issue of the Blakeley Apprendi.
We haven't receded from the Galinda's.
No, you haven't. Not from. I'm sorry. You removed that from our consideration at that point in time. That is what the state did. The state did not do anything improper, despite assertions to the other.
Thank you both for your arguments, and I'd like to especially thank the pro se counsel in both of the cases that we pro bono counsel. I'm sorry. In both of these cases that we've heard today, for your willingness to assist the court. Thank you. The last case on the court's agenda today is State versus Fleming.
May it please the court, Christine Gard on behalf of the state of Florida. I'll run through the procedural history again of Mr. Fleming's case. It is certainly the least complicated of all three cases.
Isn't what distinguishes this from the other two is that here we are actually reviewing a decision that involved a direct appeal.
From the resentencing, yes.
From the resentencing.
Yes, and part of the reason we got into this posture is a belated appeal was granted from the resentencing, and that's sort of how we get here kind of so late, relatively speaking. Mr. Fleming was sentenced in 1997, June 1997. He took a direct appeal, and his decision, that case became final somewhere around August of 1999. Apprendi was not decided until 2000, and in June 2001, he filed his 3800A motion citing Heggs. Apparently, the circuit court didn't take that well, and it required a reversal and remand back down for reconsideration of the motion. He was resentenced on April 3rd, 2003. He took no appeal at that point in time. He filed no notice of appeal. But now we're here. But then that's where we get to the belated appeal. But it jumps way further ahead in that. Then we have some 3800 motions and a 3800B2 motion filed during that pendency period that relate to that.
This one clearly presents he's resentenced, and the sentencing isn't final until after both Apprendi and Blakely, right?
Correct.
We're still under direct appeal.
So I'll just skip forward to the tail end, and then I'll come back to the Blakely issue. In this case, we don't have a Blakely violation or an Apprendi violation because we have a finding that's inherent in the verdict. This was an aggravated battery with a firearm where he shot off half of the victim's ear, and we have a concession by counsel at the resentencing hearing that the injury was severe. So the finding is inherent, and this court's found.
Is that the assessment of the 40 points for severe victim injury?
Right. The first district, ironically, found that the assessment of the 40 points for severe injury was inherent in the verdict, but the permanent injury departure, which is specifically found in the jury verdict, they went ahead and said Isaac applied to it, and it hadn't essentially been found.
Now, what was specifically found in the jury verdict that covers that?
The jury verdict, I have it, I'm sorry. He was guilty to the charge of aggravated battery by causing great bodily harm, permanent disability, or permanent disfigurement. That's how the verdict read. Then the departure reason, which happens to be departure reason 2, was the victim suffered permanent physical injury.
But that was an or. Am I missing something there?
Well, it caused both great bodily harm, permanent disability, and permanent disfigurement. And the testimony and the admission by counsel at the sentencing hearing was that the injury was severe and removed half of her ear, requiring reconstructive surgery and leaving a permanent scar.
But in terms of what the jury found, those were in the disjunctive. It could be either of those three that you listed, right? Forgive me if I'm wrong.
I think it was in the disjunctive based on what I wrote in my notes.
Was.
Is the disjunctive.
I'm sorry, sorry. I didn't mean to confuse it with sorry.
So what were the three possibilities?
Great bodily harm, permanent disability, or permanent disfigurement.
So
and finding number 2 is suffered permanent physical injury.
Okay, well, great bodily harm wouldn't necessarily cover that.
And again, at sentencing hearing, we have an admission at the sentencing hearing that I was trying to go down to it very quickly. How come I can't find it? During the resentencing hearing, there was defense counsel specifically stated there was no dispute that the injury was severe, but argued, I don't have the full text of it, it's found at page 106 of the record, but that it was not properly scored because it was dealt otherwise on the score sheet. The state's assertion is that the finding by the jury is sufficient.
The injury severe doesn't match the language, and maybe it's semantics, but again, as Justice Kennedy pointed out,
the imposition of the severity points was found based on case law saying that where you have the great bodily harm, permanent disability, or permanent disfigurement, under the case law in Florida, you assess the 40 points.
But right now, the appellate court decision says the state conceded error on all 4 grounds related to upward departure.
Carolyn Mosley handled this case for the state.
I'm asking you, is that what the appellate decision says?
That's what it says, but that's not what happened.
We're here, again, there's a significant conflict. The state must want us to decide this issue at some point, and if we've got on the 4 corners a conflict with the other appellate courts, isn't this, I mean, you can make your best argument that Blakely and Apprendi, which is what you've been making, do not apply to resentencings or to sentences. Or
yes.
Can you say that? It's a sentencing.
Your Honor, we go back to the language in Hughes, again, as we've stated previously, that is the conviction date, that is the determinative factor. So back in, for Mr. Fleming, that would be June 30th, on or about August 2nd, 1999.
Squarely, again, presents the issue that we did not decide in Galendez, correct?
And so your answer was yes, correct?
It squarely presents the issue
yes.
that we did not decide.
And that you also talked around it, and that the date here, the conviction before, sentencing after, that you go by the conviction date.
Correct.
Yes. Okay.
Yes.
That's your position.
Yes.
You're not abandoning your argument that they failed to adequately preserve this issue in the resentencing.
No, we're not abandoning it.
And so that argument is that they brought it up when the resentencing, if I understand what happened correctly, there's a resentencing proceeding, and these things are an issue.
Yes.
Nobody says, well, we need a jury to make those findings. You can't do that without a jury. Nobody said that. Then they filed a 3800B motion and raised the Apprendi Blakely claims. And your contention is, under Jackson, that's the sort of thing that's part of the sentencing process. It's not an error in the sentencing order, and therefore 3800B is not adequate to preserve it. They should have said something at the sentencing proceeding. Is that correct?
Yes.
So basically, all these tag cases that we've discussed this morning really should be resolved on other basis rather than the legal issue that we thought we were going to do. Isn't that a fair statement?
It's a fair statement that there are numerous other ways to resolve each and every one of these cases, and numerous.
Yeah.
I don't think I can name them all.
Would prefer that we decided on the narrowest grounds, I'm assuming, even though, again, at some point down the road, the issue about what's going on in all the... We discharge all the cases that were from all the other appellate courts that would have been conflicted with?
You did, but I have since been lucky enough to inherit 2 more cases that are now pending in front of this court.
What are them? Could you give us those names?
Roy Bush is one of them.
And where's that from?
From First.
Now, are there any from the other appellate courts?
I'm not aware of any.
But you see, there's real problems here because of these cases where the defendants are pro se, and there's 4 other districts that are deciding the issue contrary. We've got a real issue of the credibility, in my view, of the administration of justice.
I will tell you that Roy Bush does have appointed counsel from the Public Defender's Office. That's the only one I can say that. The other one is Sirron Johnson, Sirron Johnson. He is pro se.
But even if, and again, I'm just saying this for the benefit of the defense world too, even if we end up deciding this issue that the first district is right, everyone else is wrong, unless we decide that our opinion will have retroactive effect, those cases from those other appellate courts where they've decided differently will remain final. Right? We'd have to even if we decide this issue, we'd still have to decide whether our decision should be given retroactive effect.
I think that's true to some extent. Most of those, again, have been dealt with on harmless error. So, again, this decision wouldn't affect any of those. I think that there is another class of those that might fit within the other available remedies, either 3850 or an ineffective assistance of appellate counsel claim. There are some ones that might.
There's the case Bush.
Roy Bush.
And what's the other one?
Sirron Johnson.
And those both have appointed counsel?
No, only Roy. He had appointed, I know that there was appointed counsel from the Public Defender's Office. I can't say whether that traveled up or not. I think it did because all of those pleadings were typewritten, and that's generally a good representation that it's not a pro se litigant. And I remember having some motion back and forth with one of the counsels from PD's office.
Are those post-conviction cases, or are they direct appeals from the resentencing?
Sirron Johnson, I'm pretty sure, is a post-conviction case. Roy Bush, I don't think he is. But if you take a look at the file, you can tell it's in a different procedural posture. It involves the violation of probation hearing issue.
And that's probably a whole different...
Well, I would suggest that there are important Blakeley and Apprendi issues probably in both of those.
On this issue of whether it was preserved properly in this case, and I agree with Jackson that we didn't intend for the exception to be anything that happens during sentencing. Have we held, or has any court decided, we've decided that Apprendi isn't retroactive, but the denial of the right to the jury trial, have we in the Apprendi Blakely context say that that's something that can be waived by not having raised it in a timely way? Have the appellate courts looked at that issue?
I am not aware, unless I cited a case in my brief, of any federal or other state case. That doesn't mean there isn't one. It just means I haven't located it. And as you know, this is a huge body of law now. It grows exponentially every time I go to look at it. I don't know that any other state has found anything on preservation-type grounds.
Either way?
Either way.
So then that argument as to whether this would be fundamental error...
Well, we know
we haven't asked you to brief that issue.
No, but we know that it's not fundamental error. It's not plain or structural error from the United States Supreme Court cases of COD.
But under our issue, when we say that it can be raised, because we haven't said that it must be raised, or that in the future, if the judge doesn't afford the defendant the right to the jury trial and the facts found, is it the defendant that has to affirmatively request a jury trial, or is the trial court charged with that responsibility in conjunction with the state and the defense?
I take back my previous statement. I was not thinking of Rosen until you discussed discuss that subsequently. In Rosen, facing a little bit different issue, the court, I think it's the 5th District, it is cited in the briefs, I believe. I hope it's cited in the briefs in this case. It's keeping them all straight, that's the problem. The court in Rosen found that Blakely and Apprendi errors should be preserved.
In one way it makes sense to me that it's a right of the defendant, and it's certainly something that they can waive, but normally when there's a waiver of a right to trial by jury, there's got to be a knowing waiver, not just the failure to assert it. So that's why I'm concerned about simply saying that that at least in a direct appeal, that can't be looked at because the defendant, there's no indication the defendant made a knowing waiver of the right to trial by jury.
Well, again, but he didn't make a waiver of the right to trial. He expressly intended to go forth with the jury trial and had a jury trial, and he should have then asserted during that jury trial that if you don't have these specific findings, then you don't get what you want.
Again, the idea that why is that the defendant's responsibility? It's his right. It's not one that the Supreme Court has said has to be affirmatively asserted by the defendant. I mean, in future cases, we're not going to be saying there's some procedure where, unless the rules change, where the defendant's the one that has to, it's the state's burden. If they're going to ask for enhancement of a sentence based on a fact, the jury's got to find it. They can't say, well, the defendant didn't ask for that. The defendant doesn't know which facts they're going to rely on. Isn't it the state's burden to make that to bring that forth?
Again, the purpose of if you look at the Rosen Court's opinion, they ruled on this based on the contemporaneous objection case law, and the purpose of contemporaneous objection is to avoid surprise by crafty litigants and avoid injecting error into a trial.
But isn't the right to the jury trial treated under a different rule in our rules of criminal procedure than preservation of those issues?
Well, again, the right to jury trial
isn't it just treated differently?
It is if he's denied his right to jury trial, but he wasn't denied the right to jury trial. He had a jury trial, just not all of
the rule doesn't say you may be entitled to part of the issues. Isn't that to decide for your trial? And this should have happened during the trial. Isn't that what that says?
Well, but again, if we don't instruct on an element of a crime, we don't suddenly grant reversal on jury trial grounds. We do it under the contemporaneous objection rule.
This is the better analogy.
Unless it's a fundamental error.
Correct.
Yeah.
The state is wanting to get enhancement based on a firearm, and the jury never makes that finding. Are you telling me that it's the defendant that better say, oh, state, you need to put that finding in? It's when the defendant wants the benefit, it's one thing. But when the state's asking for the benefit, that's exactly what Apprendi and Blakely are saying. There's got to be a jury determination.
I understand Your Honor's position, but in those cases, in order for this court to grant him relief, you have required he object at sentencing. Even though it's a trial error that occurs even though it's an error that occurs during trial, it becomes manifest at that sentencing proceeding. Here, he didn't object at the sentencing proceeding at all on these grounds. So the result is, no matter which way you look at it, under the facts of this type of case, and under some of the cases we've already discussed today, the conclusion has to be that he didn't preserve it properly. And with that, I'll reserve the remainder of my time for rebuttal.
May it please the Court, my name is Dave Davis, representing Mr. Christian Fleming here. I have sat through the previous two arguments and have a greater appreciation now for the problems you have, because I looked at my case and say, I don't see really a big problem here, because Justice Kennedy, going back to your post-conviction land statement, and it was brought up by Mr. Mills earlier, that when you're talking about a 3800A, you're talking about you can raise an illegal sentence at any time. Days, weeks, months, decades later.
Sure, but you would agree, again, I know you're here for direct appeal, that an Apprendi era, a Blakely era, is not going under the 3800A. It's not. We didn't even hold it was retroactive in Apprendi, so it's not the kind of error that makes a sentence illegal that can be raised at any time.
But what you said.
Do you agree with? Can you answer
well,
that?
I don't know.
Well, I'll tell you the answer is you can't.
Well, let me say this: that what happens is when you go to a resentencing, all bets are off. It's a brand new sentencing. And so the state of the law existing at the time of the resentencing applies.
Some of us, I think we agree with you on that. But let's talk about then this issue. I guess the question is, do we talk about the issue of preservation?
Well, it was preserved. He filed a 3800B2.
But what about Jackson?
Jackson. When I read Jackson, I think you list some things in Jackson which talk about can be covered under a 3800B2, and I think an Apprendi type error could be picked up on one of those things. I'll be honest, preservation was not raised by the state here, and so I did not look at it that seriously, because for me the 3800B2 was not ruled on, frankly, by the trial court. It was considered by, or at least the Apprendi Blakely issue, which was raised in the 3800, was considered by the first DCA, and that's why they reversed it. At no time do I see in any of the states' briefs, in this case, that they...
But, in fairness to the state, I'm looking at the brief, and it says, and they say a lot of things. It's all over the place, but they do say, additionally, in the instant case, Fleming made no objection based upon Apprendi at his resentencing hearing.
It was at the 3800B2. That's where he raised the Apprendi.
Okay, well, but then they also say, don't they argue here that Jackson means that's no good? Or am I getting this mixed?
I don't, like I say, I didn't pick that. If they had said that, I would have responded to it, but I don't recall them saying that. Now, I may be wrong, Your Honor.
Did they make that argument before before the first district?
I don't know.
I mean, that would be, because they would have to preserve,
right.
It seemed to me, that it wasn't properly.
That certainly wasn't mentioned by the first DCA in their opinion.
Well, in all due respect to any court, they don't have to.
Well, that's true, but I just simply don't know. But like I say, when I get them here, when I got their initial brief in this case, I don't find any objection on Jackson grounds.
But do you lose if there is no error in the assessment of the 40 points for severe victim injury?
Right.
Is that the end? Is that the end of the case?
Well, the judge also had 4 reasons for departing.
So are those? So let me say, I always like to hear the real world issue. What was his original sentence before Higgs?
I thought it was 20 years. You said it was 25? 25. It was 25.
Okay,
But then they knocked
years, but then he
gets Higgs relief.
And what would his sentence be without the departure? What?
I don't know. What was it? 55 months. That's
55 to 92. So
55 to 92. So that's almost 5 to 6.
A very significant
yes,
difference.
It would have been almost cut in half.
Given though, and would that be including in that 55 months? Does that include the 40 points for severe victim injury or not?
I believe so. Yeah.
It does.
Yeah.
So what was his departure sentence then? Was what?
About 10 years.
So he at least got 10 years.
I'm sorry. He got the Higgs relief. He got 5 years, and then when they approved the 40 points, that's what gave him 20. The court used that to give him 20 points with those 4 other departure reasons.
Well, what did the judge resentence him to?
20 years.
And what would he, if the 4 departure grounds are in?
It would have been 55 to 92 months.
But what would there be left to reverse on if the state's conceded error on all 4 grounds related to upward departure, which is what they say? But are you saying that their statement of not being error in the assessment of 40 points for severe victim injury is something that the jury should have found?
I think so, yes. And then
you've got to know whether you're saying it or not, because what's the relief you're asking for? What would be? He didn't get a jury trial in resentencing, but they've already conceded he can't get the 4 upward departure grounds, and it looks like the 40 points are inherent in what was found.
Well, that's a good point. I'm not real sure once you point that out, what sentencing relief we are asking for, other than that he would have gotten relief under Blakeley and Apprendi. That's a good question. I hadn't really quite looked at it that way, but so I think you ought to just simply affirm and just let him go on his way and get resentenced without those 4 reasons. So he goes back and resentenced to 55 to 92 months.
But then the Blakeley Apprendi issue is completely moot, isn't
it? It's moot in this case, yes. So let's just go back.
Let me
I hope we're not laughing at this situation. There are both the state is, I know everyone's trying to be earnest in this, and it's really an unfortunate situation, and the court can't pick the case it wants, and so but we have to be dealing with the case in front of them.
Right. I mean, there's got to be some controversy, and if I think if the first DCA is correct that Blakeley and Apprendi apply. Then what the first DCA is saying is you go back and have another little mini trial on those 4 issues or 4 departure reasons. And what we're saying with the state's concession, there's really no need to do that because the state's conceded those reasons aren't valid. So we can go back and just go have resentence within the guidelines of 55 to 92 months. And I'd be perfectly happy with Mr. Fleming.
Well, on the other hand, maybe we let the first district figure out what they meant by...
Well, I think when the state conceded those 4 reasons, there's really no issue. Really, frankly, now that you mentioned, there's really no Blakeley and Apprendi issue simply because the state's conceded those 4 grounds. So what do we do? They go back and just let him be resentenced?
Well, let me take you back to
we don't have appellate mediation for this case.
Yes, sir.
But let me take you back to the preservation issue. You said you didn't think that had really been raised by the state. Well, it was. I mean, at great length. I got the brief in the right case. State v. Fleming.
Right.
Okay, pages starting on page...
I see what you're saying.
Yeah, on page 32, it starts and goes on for several pages where they begin by saying Fleming's Rule 3800B2 motion is likewise insufficient. They launch into an extended discussion of Jackson, and then they end up, Fleming's claims are not of the character that are permitted to be preserved by Rule 3800B2 motion. Why is the state wrong about that?
Well, because as the first DCA ruled, they conceded those 4 rounds. And at that level.
Well, isn't what they conceded is the state of the law in the first district?
The state concedes error on all 4 grounds.
Well, I know what the opinion said, but isn't this the state's position that what they conceded that we got to deal with Isaac, I guess it was, at that point, in the way the first district had decided Isaac. Isn't that what they were conceding?
No, I think they
were conceding.
You don't think so?
No.
Okay,
well, it says here, let's just go what they were conceded. The appellant also argues the first 3 grounds for upward departure were found by the judge and not in jury in violation of Apprendi, and the 4th ground is invalid on its face. The state concedes error on all 4 grounds related to upward departure. It sounds to me like they conceded that there couldn't be validity to one of the reasons, but that the other 3 would be subject to Apprendi. And then at that point, it would become, they didn't decide the issue about then on remand. What is your position, assuming that we would say that it is preserved, because that's not on the face here, and we just whatever, we look at this issue. On remand, is it the defendant's position that the state has to abandon anything that hadn't been found by the jury, or that a jury, like in a penalty phase, could be reconstituted? Because again, these, in fact, even the resentencing or the departures are heinous, atrocious, and cruel, avoid arrest, things that juries are instructed on all the time in penalty phases.
Let me see if I'm
asking you whether if Apprendi should have been followed, then it seems to me that in this case that would mean that he would get a jury trial on those 3 departure reasons.
Well, I think that's...
on the other, or if any of them end up being conceded to, then it's one. All you need is one valid departure reason to upwardly depart. Correct?
Well, these are discretionary rulings, in some degree discretionary rulings. So whether it's, I guess you're going to talk about harmlessness. That's the latter part of your question there. I think you need to turn it back to the court and let it make that discretionary ruling. I don't think
first district.
Yes, to turn it back to the trial court to let it make a determination of harmless. Well, determine whether it would have found that factor, or would have sentenced him as heavily as it did without the other 3 factors.
Can I take you back to the question I was trying to ask about the 3800 B2? Let's put aside all this. I understand what you've said about that. But putting all that aside, can an Apprendi Blakely issue be raised by way of 3800 B2?
Well, like I was responding to Justice Periente, that question was not really clearly presented to my mind by this case because it was.
Well, it's presented very clearly by the state.
Well, then I think if you read Jackson, I think yes, you can, because it's one of those because it's one of those areas that adheres in the sentencing itself. It's part of the sentencing that.
Does the right to counsel? I'm sorry. If you don't mind, does the right to counsel adhere in the Senate?
The sentencing phase, yes. He has a right to counsel.
Never mind.
I guess the question, and I'm sorry if I cut you off. What I'm, again, going back to is this issue of, one is, you didn't respond in the brief, as I'm understanding, because we only asked you to
respond to
So if we want to consider the B2 issue, would you want the opportunity
yes.
to do supplemental briefing?
Clearly, if you want me to do that, I'll be glad to do that.
The other issue is that I guess the answer would be B2 was we tried to take a narrow group of issues that could really be resolved by the trial court, that there was a score sheet error, or there was this, or they didn't check this box and send that back. Issues that could be like if there was no counsel in sentencing, but that's a B2, that could be raised on direct appeal without having had it preserved, I would think. But we'd have to get into that question as to whether it could be raised on the first time on appeal without going through B2. And you would want an opportunity to address that question?
Yes. Yes. In any event, I think the points I want to make is 3.808 allows you to raise illegal sentence at any time, and you start with a de novo proceeding in which you take the law as it exists at that time.
Do you contend that Apprendi errors or Blakely errors result in illegal sentences under 3800A?
Yes.
But we don't need to, just to make, we don't need to decide that bigger issue.
Not in this case, no, because we can send it back. Thank you very much.
Just briefly, Your Honor, we did not concede error with the exception to ground number 4, which is the level 7 and level 8 offense thing. That's what we conceded. That's the only thing we conceded error to. The other ones we stated that the state of the law is that we have Isaac. And as a result, under Isaac, the court's decision's predetermined, which is, I think, what you said. So that's where we were at. There was no concession that the other 3 departure reasons were not valid.
Okay, so what you're saying, what you're conceding, that if Apprendi Blakely would apply, the other 3 departure reasons would be the kind of reasons that would have to be found by the jury.
Or could be found under harmless error under Galinda's. Yes.
Okay, so that at least we have this pretty swift. And that does sound like that's what it says. At least we got that squarely presented. Now, was the 300B2 that issue that they raised it that way, and then the appellate court's deciding it? Did the state raise on appeal to the first district that it was not properly preserved because it should have been raised at the time of sentencing?
The state was not required to because the state was not the appellant. We were the appellee below. So the state doesn't have a preservation requirement before it.
But if they're making an argument that Apprendi or Blakely apply, the state loves to say, but it wasn't preserved.
Well, we might love to say it. The state of the law was that it did.
If it's not preserved, to advise the appellate court of that.
It's not, there was no preservation issue. We were not the appellant. And because of the state of the law, the state of the law in this case, the state is free to assert tipsy coachman at any time. And it's essentially a tipsy coachman reason to affirm.
Okay, I just want to make sure.
Or to reverse, I'm sorry.
A straight question. When that issue was being briefed before the appellate court on whether Blakely or Apprendi should apply, did the state in its answer brief, say this is not properly before the court because the issue was not properly preserved?
I don't know. I really don't. I don't have the brief with me here from the lower court. And what I can tell you is Bertha Jackson didn't come out until long after it was briefed. So the issue of 3800B2 would not have been as Jackson, as it's written here, would have even been available.
Tipsy coachman. You're really asserting tipsy coachman with respect to the trial court.
Correct.
Not tipsy coachman. Can you assert it back beyond the level that we're reviewing?
Your Honor, I'd be happy to brief the issue. I don't know.
How is there a tipsy coachman issue? If there was error in the trial court not deciding departure reasons without a jury finding, what tipsy coachman would allow you to affirm on an alternative ground that the trial court didn't err?
The trial court found, if I remember correctly going back, they found Apprendi didn't apply at all, which fits with the state's argument that the conviction date is what controls under Hughes. So that's where that comes from, and as a result, their argument, their position would need to be affirmed. The trial court's position would need to be affirmed.
That's what you've been saying all morning, which is you want us to go with the view of the other four districts, and then we don't have a resentencing here, correct? I mean, that's it.
No, that it doesn't. That Blakeley and Apprendi don't apply to the resentencings like this.
Like this one, which is this isn't a ministerial one, is it? This was
no. This is a Heggs resentencing. It's a Heggs. So
it doesn't apply to resentencings.
That this particular right does not attach to the resentencing because the conviction date is what controls. Citing for that proposition Hughes. With that, I thank the court for its indulgence.
Thank you for your arguments here today. The court is now in recess.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.